morning. Good morning. Good morning, everyone. Oh, I got something in my eye. That sucks. It's Friday. It's Friday. I'm so happy for it's Friday. I think maybe. I don't know. I feel like I got something in my eye. I can't tell what it is. I don't know. I think today is like a wing it Friday. I sent out the alert like to see. And of course, I don't know what court TV got going on in regards to this trial that we were trying to cover with our Jordan Palmer Millman trial. It would have been nice if they would have it on here, right? There's no telling. I've been trying to see all morning, like if they were gonna do it. I know yesterday they were trying to stream it with the Ali trial. Like while we were waiting on the verdict, they were like giving us parts of it, but I don't know. I was like, I can't leave and not be able to see my people on Friday, right? So we got to do something, right? So we gonna do something, even if they don't play it. I guess they just not gonna let us see it. Which is weird. I don't understand it, but it is what it is. Hey, Fala. Do I got the other stream? I got that open. Oh, y'all want to talk about it? Everyone is in the other room. I got that scheduled for this morning. Y'all know I'm cray cray. It's so crazy that we almost probably should be in the other room, quiet as kept. And you know why? I don't think they're gonna let us. I don't think they're gonna stream this trial. They have it up here, but they won't. They not streaming it. But I was like, I don't want to. I didn't want to not see y'all, so that's why I did that backup thing in regards to the Ali verdict discussion. So just in case anybody wants to kind of come up on the panel and talk about it and express their feelings and emotions about it, right? Since it was such an emotionally charged trial. Yeah, said she appalled with the verdict. But good morning, Hazel. Good morning. Oh, I am so goofy. Do I got that scheduled for this time? Because I could be real goofy. Let me go check it. So goofy. You say you don't want to? Okay, well, let's do this. Oh yeah, I got it scheduled for like 1. Hey, Jason. Hey, P. Lolo's mom. Oh, wait. Sorry, guys. Oh, I had to sneeze. Ooh. I thought it was gonna come. It's about one of them sneezes that you think gonna come, but it don't come. So, you say I disagree with the verdict. The end. Yeah, I said that I'll let people in case they want it. You had it scheduled for the Ali chat thing or this one? I know I sent the alert notification out this morning. Yeah, I got it. I got this one scheduled for 7:30. That don't look like it's gonna happen. And then I had the Ali verdict breakdown open panel discussion scheduled for 1:00. Is this the Ali chat? Did I go into the wrong room? And I could do that too. Oh, it is. Y'all are right. Like we in the wrong room. That's fine. Just stay here. We gonna stay in the Ali. Oh gosh, yes. Oh gosh, girl. I'm all in the wrong thing. I done clicked on the wrong thing this morning because it's at the top instead of the bottom. Well, that's fine. Perfect. It must have knew what need to happen, right? We stand in this room. We ain't moving. We ain't going nowhere, and I ain't opening up the other room. So you don't even have to worry about it. Everybody come here talk about the Ali, and I'll talk about some other thing. Look, no. Look, I got the coffee. I don't know how I clicked in the wrong room, but whatever. I'm telling you, things happen for a reason. Because when I go on court TV, the Jordan Palmer stuff that I was trying to do, that it is not they're not streaming that trial. And I don't know about y'all, but I definitely know how I feel about stuff like that. Like I do not I don't like doing chase down trials. I just don't. I don't prefer it. I don't do them. I don't like them. I'm not gonna be chasing down testimony everywhere. I'm not gonna be trying to piece testimony everywhere. I'm not gonna do that. Me personally. And you know what's going on? Yeah, I needed to send an alert to my phone. Yeah. I think I originally had the other one scheduled for 9:30 at night. Now, how about that? And it was so funny because somebody was like, are you streaming at 9:30 at night, or do you mean 9:30 in the morning?" I'm like, it's definitely 9:30 in the morning your time because I am not streaming nothing at 9:30 at night. Yeah, if they'll let me see. Let me go over there. I'm so goofy. Let me go see. I'll go check it. They'll probably start making their way over here because I deleted it. I call myself deleted it. Yeah, I follow. Yeah, I'm out here in these streets, like out here. I came in and I'm like, okay, I got something in my eye. I don't know what I got going on. I got to use my camera for my eye. Well, I guess we'll get to it. Let's see what we got here. Oh, this is what I did want to show y'all. Look. Before we kind of talk about that. Hey, film. I know. I'm all over the place today. Okay, so let me show y'all this. Y'all tell me what y'all think about this. Hopefully everybody can see it. So this trial right here that I got up is starting Monday. Y'all see it? So with this trial, this guy Nicholas is 43 and he's facing multiple charges. I'm just reading off the thing, including malice murder, Oh, unaliving. I better say unaliving. I tell you, just trying to read these things. My bad, homie. From November 2022 and the death and the unaliving. Look, I can't even read this stuff because I got to figure out how to do these words. Of Mindy. Her remains were found in December, on December the 2nd. They were found in 2 different locations. He was arrested in Pennsylvania on May 12, 2023. They haven't released the motive. The weird thing about this is, I don't know if y'all see right here, it says that the authorities haven't released a theory on motive, but a pretrial hearing in July, prosecutors argued that the couple, so that means him and Mindy, were on the run to avoid paying a $1.5 million divorce judgment to Nicholas's ex-wife. His trial is to begin on, I don't know. Do y'all want to cover that? Hey, the Jules. Good morning, Rita. Hey, Madison. Yeah, the room switched. Sorry, guys. Hey, Tara. Hey, Zach. Good morning, Happy Face. Hey, Blah. Anybody that I missed? I scrolled up a little bit for us. Hey, Libby. Yes, I responded. So I don't know. Y'all let me know. We'll decide if we're going to cover this one or not. I really don't like. See, look here. When I click on it, it just go back to the testimony that they keep replaying. Okay, so hey, Amy. Yeah, I don't have it planned. Gina. Hey, V. Thank you so much. Okay, so let's do this because I think that we should start doing this when we're not moving so fast with trials. Like, I know that some of these verdicts, and we don't have to just discuss the Ali verdict today. We had a couple verdicts this week that we looked at. We had the mom that was attempted to be unalived by the husband, and he was sentenced this week. So we covered that one. We also had the basketball player where he was sentenced. So with any of these, if anybody wants to talk about any of these topics, I'm gonna drop. You said Madison. You said, "Girl, I was ready for it too." I don't think they're gonna let it happen. I don't think they're gonna let it happen for us. I've been trying. Yeah, the queso trial. We looked at that verdict. The dentist, right? So any of these verdicts that you have that you want to talk about, I just know that the Ali one was really emotionally charged, and I said, well, I opened up a chat discussion, and if I want to drop the link in the chat room, who gonna volunteer to come up here and talk to me? Let's discuss this. Get it off your chest. Please get it off your chest so we can move on. I was like people last night because I had to go to, I didn't want to feed the kids Cheerios last night. Oh, you would love to talk. You gonna come up here, Jesse? You gonna talk to me? I'm gonna drop the link in the chat. And let's just discuss. I mean, we had so many verdicts. I should have just put a list up here of all this stuff. But I know that the Ali one was really dear to a lot of people's hearts. And I was like, well, dang. I want to give you like a free space to be able to respectfully. You did? Oh, really? All I did was reply. Sorry. All I did was reply. So I'm sorry. I'll check. I don't think it came back unless I was in a dead spot when I was doing it and it kept it as a draft. Hey, Rachel. Good morning. Yeah, I'm kind of upset about this Montana stuff. To be honest, y'all. It really put me in the because I just can't stand trials where we have pieces of information and they don't show you the complete trial. And then even when you go to try to look for the stuff, you can't even find it. It's like, don't be teasing me with that crap. Now I'm trying to figure out what's gonna happen. So, do I have any takers? Who coming up? I'm gonna drop the link. Rachel said, don't make her come up here. I'm gonna drop the link. And as you decide if you want to come up here and talk about it, I know sometimes talking things out versus to typing, right? It could be a little easier for people. At least I know for me, right? I don't mind chatting, but I sure like talking. It's more easier, and I don't have to figure out how to get it all up in there. Okay, so I am going to drop the link. It'll put you in the back. And I think it could be up to 10 of us up here at a time. So we'll just kind of do trial and error, as long as everybody respectful, not talking over each other, and we having good dialogue. Even if there's mentions, we can even replay it, different things, but the verdict. So let's do that. Here is the link. Gina show be cooking. Did you I bet you used that fried chicken recipe yet, Gina? I worked hard on that. I was like, I've never typed out a recipe. This is probably gonna take me forever because I'll just be throwing stuff together. Like, I could never do a recipe book. I didn't see that, P. Lolo's mom. But I don't know. I wouldn't be surprised. What you say? You got to keep. Y'all gonna keep making Rachel come up here. Look, I'm gonna add you to the stage.
Oh, whoa. I just heard an echo from you.
You got something else playing with it on?
Yep. My bad. Oh, that was me, not you. Listen, I have to come up here. I have to talk.
Okay. I'm game for it. I like people talking about it versus all this type. Like, I can see the chats, but sometimes they get to moving so fast. But I know people get it off. Everybody can kind of get it off their chest.
I know, right? All right, what are we talking about first?
Whatever you want to talk about in regards to the verdict. I mean, any of the verdicts. Like I said, I've seen so many verdicts, but I know that this was the most.
Yeah, we got to talk about Ali first, for sure.
Okay.
The jury has a very narrow view. We see so much more. Like, this is just an example of how, well, no, let me back up. Number one, my first reaction was, did they not watch the video? They watched that video 100 times. I don't get that. And her injuries? So I would love to hear from a juror, because I'm wondering if they think that he just fell on top of her and the pressure caused all of this. I don't really get that part.
Yeah.
I can understand it not being guilty on. Hi, Broken Baker. Hello. I don't think that the sorry, I'm starstruck by Broken Baker being in the chat. I don't think that maybe it was overcharged because the whole M situation, but not being able to have a motive. Like, this wasn't just a punk kid running away, right? I mean, obviously there was more fear involved. I think that was a mistake, and I don't know the politics over there in Washington, and I don't know why exactly that decision was made to keep that background out. But let's just say, I mean, okay, so we left that out. We saw that man assault her on video hundreds of times. I don't really understand that. I don't get it.
Okay. So I guess what I would say is that I'm gonna play devil's advocate. I tried
I
to
know you will, and I'm gonna let you go for it.
tell y'all, y'all gotta we need to think outside of the box on this, right? So, and I'm not saying this is my. Let me be clear with it.
Yeah.
This is my opinion. Just thinking outside the box. And I only say that because I don't know all the details because I was not a juror. So that's going to be my first disclaimer. But what I want to do as we talk about this, as y'all give me your thoughts and we discuss them, is kind of give you the opposite because that creates good dialogue. And I'm not saying that this is something that I hold fast to, but I do think that it's good dialogue. So I'm going to start with this. My first thing, okay, now we know that the honor K was not included, right?
Right.
Nobody can tell me besides the news source of Court TV saying this, that this is what happened. I want you to think from the jury's perspective. We know that somebody said something about it, but does anybody have any documentation, or do we have a man that came out from over there? Do we have anybody else from the family? Do we have, and I only say that because we know, I'm not saying his actions, but when we're thinking about, I wonder if the media, to get people in tune and tuned in to, how they just.
Well, there had to be some evidence that this was the motive, or they wouldn't have been able to motion to keep it out.
Okay.
Right. So they can't just make up some random motive without evidence of that. So my assumption would be, and maybe I'm not an attorney, whatever, but my assumption would be that they had some evidence they wanted to present, testimony, whatever, that the honor K was what was actually going on. And then that's why the defense motioned for them to not be allowed to use that. I mean, I don't know what that evidence was. I don't know if it was testimony or whatever, but I mean, I think it's a big mistake. I mean, why can you not allow that motive in? I mean, I kind of get why they did, but yeah, it's crazy.
And honestly, I thought that they had enough to convict without that in there.
Well, I did too. I mean,
Yeah, but
yeah. So, okay, so the assault, I mean, he's not guilty on everything except for the basically it's not kidnapping, would they say unlawful restraint or something?
yeah, imprisonment.
So on Isaiah's him punching Isaiah, he didn't even get in trouble for that. That wasn't even found guilty.
I'm
and
not.
Assault. Paula said and assault. So he was found guilty on assault for that.
Yeah, I don't know if they had the assault charges as two separate. It doesn't sound like they had them as two separate charges, like one against the daughter and one against Isaiah. Because mom also, she was found guilty of the unlawful imprisonment.
No, I didn't think so. I think she just got found guilty of what you call it, the my mind just went completely blank. I'm sorry.
No, you're
the restraining, the violating the court order.
No, she was found guilty of wait.
Yeah, I'm looking it up too because I'm like, wait a minute, now I'm all mixed up.
No.
So he was found guilty of everything except for the M charge. She was found guilty of the violation of the protective order.
Okay.
Right.
Else.
So the unlawful imprisonment charge in Washington is punishable up to 5 years in prison.
Okay.
I'm looking. So yeah, he was found guilty of the lesser charge of assault in the fourth. And I don't know what the sentencing. Let's see, I can find it. Washington State sentencing.
We have Colorado
that's nothing.
room. I'm gonna bring him up on the stage too. As long as we should be everybody putting their input. Colorado, I'm about to bring you up on the stage.
So the 4th degree assault is up to 364 days in jail and
Sure.
$5,000 fine.
Okay.
Hey, Colorado.
Hey,
How you doing?
good.
Yeah, so that's like probably, I don't know. Yeah, he's already served 10 months, right? And so they might give him time served for that. For the assault, it was only like a year in jail and $5,000 fine. After all is said and done, all that violence and her being in the hospital for several days with her throat strangled. That's crazy. That's wild. I hope a juror speaks out, but for their sake, I kind of hope they don't. And they might not. You know what I mean? Like if I were a juror on that jury, I would not want to speak out. I'd be like, forget I was ever involved in this. But not because of the decision, just the case in general. But it would be nice to hear what was it and all their walks that they took. I've never seen that. Like they took a lot of walks.
Oh, the juror?
Yeah.
Oh, I didn't hear about that.
Yeah, they took walks outside. It was like they're taking a break to go take a walk outside. Like, oh, all right.
I wonder
interesting.
The clock during those periods of time because I didn't see
They stopped it.
Oh, I didn't see it like.
Yeah.
I mean, I wasn't watching it every moment, but I didn't.
Yeah, it was like 3 o'clock stopped. Did they have a question? No, they're just taking a walk. Like, oh, okay.
How funny.
I also want to know, while Colorado figures something out, you look deep in thought over there, but I also want to know what the, we'll never know because this is all sealed and it should be, but the CPS reports, I mean, I'm very curious if he had been substantiated for abuse and on the registry for that, because that's a much lower bar. They don't need criminal court to say, oh, you're substantiated or guilty or anything. They can just say, according to our investigation, we've substantiated you for child abuse. That means you're on the registry. So, you can't be a teacher. You can't work with kids and that kind of thing. It honestly probably won't affect him that much, but at least to acknowledge for the victim that we see that this happened. You know what I mean? So.
Yeah. Yeah, I get it. Are you ready, Colorado? Give me the thumbs up.
You're muted.
I muted him because he was.
Oh,
there we go.
Talk up for you. You're good.
Good. I'm still in kind of shock from the verdict. Can you hear me okay?
Yep.
I didn't expect this at all. I mean, the first phrase that came to my mind is this some kind of jury nullification, like we saw with OJ, where like one jury just sat there with their arms crossed and says, I will absolutely not budge. We either do this or we have a hung jury. Because it was just, I mean, when the defense is doing stuff like, well, what is strangulation? What is death? Is my truth the same as your truth? Whose reality is real here? And this guy was just it was so obvious. We had the videotape, we had the medical with the pedicle in her face from the capillaries bursting in her skin from the pressure on her throat. All the medical stuff was as plain as day. There was no doubt about any of this. So this has to be some kind of jury nullification or some kind of meddling, because I mean, he was red-handed. We have him on every witnesses. Look how much effort it took to get him to stop. He wasn't just in Iraq, this is just how we discipline our 17-year-old daughters, is we strangle them until they're unconscious and then, Jesus. Sorry.
Yeah, you're right. That's a good point though about him. Like he didn't stop easily. It took how many people kicking him in the head, pulling him off to try to get him off, and he was not, like, there was a mission. He was on a mission there, right? So that you're right about that. I mean, I'd be really interested in how, even though it wasn't part of the trial, how culture influenced that jury. Like, what's the jury made of, and how that was influenced, because you're right. I mean, how can you watch that video? I mean, we saw the blurry video, right? And we can still say, oh yeah, red-handed.
I wonder from a legal standpoint what allowed them to exclude the terms honor killing and arranged marriage from, and they're taking a walk. You could see a newspaper, they're supposed to be sequestered. You can't just take a walk. Were they trying to do a mistrial?
Well, I had that same thought too, and I don't know legally, but I thought, they're not allowed to talk about this outside of the courtroom, outside of the jury room. They're all going on a walk together. I mean, yeah, they go home at the end of the day so they could be exposed to anything, but that just seemed really odd to me. I feel like if I were a judge, I'd be like, okay, no, if you need a break, you take a break in the building and get back to work. Like, there are people waiting for your decision. Like, a break is fine, but you're not going on a half an hour walk outside. I don't know. That's a little weird. I've never seen that before.
I wish I had been able to see when Fatima was testifying her face. I realize she's a minor, so we can't, but I could hear in her voice. It really was crushing to me when she would just, in her testimony, when she would just break from stress, and the attorney would say, "Your Honor, this would be a good time for a break." I think to hear the terror in her voice. This wasn't a girl who was afraid of being put on restriction or grounded or something. She was afraid for her life. And I think even though we've got this horrible verdict, it still helps to highlight the problems of honor killings and arranged marriage and the I word in the United States. Are we allowed to say the I word now, or the M word? Jesus. I think it helps us to see. I'm from San Bernardino, which is where there was another massacre by these I word people. So I have I've got some skin in this game. I've got a dog in this fight. I've got a chip on my shoulder because my religion, which I won't mention here, is diametrically opposed to theirs. In my religion, we see the Creator as female, as a goddess. So any religion that seeks to denigrate or control women the way this one does is our antithesis. It couldn't be more different. So I've been watching this case since the start. I'm amazed and appalled at this verdict. It's going to be as soon as she can go on the talk show circuit, Fatima, we're going to see her on every talk show that exists. We're going to see her all over YouTube. This is, even as appalling as it is, it's good because it draws so much attention to this problem.
Oh, you're muted.
Oh, sorry. So let me ask you, and this question can go out to either one of you. So if we take off the table anything affecting the jury, like any outside influence or anything like that, is there a possibility that the film and the video that we were not privy to, right? Because we know that there's video and film that we did not see. Can we agree upon that? I mean, we seen video, but we didn't see the gentleman, the minor that had the fake, that had the mom, in some kind of account that I'm sure the mom was in there at some point in time that we did not see. And also the bus driver's different video. Y'all remember?
We saw some, but it was blurry, and I don't think we got to see the whole thing either.
So I guess my question would be is that if you're reasonable to think that the jury just may have more information, and maybe is I don't know if the verdict came out right, but I kind of blame the prosecutors in a way because it seemed like the instructions, it seemed like it was just too much, or like, why are we putting in burglary and all this extra stuff for us to go? Like, it just seemed like it may have been cumbersome, and I'm thinking that they may just have more information also than what we have.
I think they had less than what we had, honestly.
Yeah.
And I think if the judge, essentially, there's not much detail about it. to read about, but basically they couldn't mention the honor K because they couldn't, the judge said that would be prejudicial. Well, I almost wonder if it was unclear to the jury, like had they had that motive, it would have made things clearer. Do you know what I mean? I imagine some discussion about motive and, hemming and hawing about, well, what maybe was it, but it's like, so if you can't present that and you can't present evidence of that, then you can't make a determination of what was really going on. I just think that was a huge fail for Fatima to not allow that motive in as prejudicial. Well, then you leave it up to everyone to just, take their own beliefs about what may or may not have been going on. I'm sure arguments in the jury room about, well, that's not all Muslims. And, I think it created probably a very unclear situation.
Yeah, I'm sorry. Go ahead, Colorado.
Oh, I don't see how, even if there was evidence that the jury saw that we didn't, or that we know that they didn't, what we did see was absolutely damning, and that there could be no. I'm an emergency medical technician, so I know a little about what she was going through. I've seen the bruises on her neck. I've seen the pedic. I mean, this was serious. He wasn't disciplining her. This man's full intention was to kill her. It takes about 2 to 4 minutes to actually strangle somebody to death. So what you see in the movies, that's baloney. It takes 2 to 4 minutes to somebody intending in every second to murder somebody, not discipline them or put them in their place. So I feel like we've gone through the looking glass here with what's real, and his intent was obviously to kill her. So it cannot be that something has gone strange with the judicial system or the jury.
Yeah, I guess I mean I just I mean I don't know, and I don't know what they can do about it. If there is there any, I mean, at this point in time, right, we're here, but I guess it's just kind of like working in regards to the future. But I don't know if they it seemed like they only bring in that honor K stuff. I think they only allow that in, like, and it's unfortunate that when it actually is completely carried out. At least the one time that I did see it like brought into a trial. So in that regards, I'm like, well, what do you do? What do you do with that? But I really honestly thought that they had enough to convict without it. Just on a dead, just two human beings, right? Because I just,
Right.
two, when we talk about the mom and the dad, two bad human beings, regardless of whatever their case may be, or bad parents that put their daughter through this distress, like, because what if he would have passed away? Like, are you serious? So I really thought that without that, like, you couldn't have told me. Because even when I look in the comment sections after I put up the videos, I'm like, oh, don't worry about it. They're gonna be fine. Did y'all see the video? Like, we don't need that in here.
Right.
And it would have been nice if that would have been the verdict. But I just wonder, like, what did they not see in the video that we saw? It was something that they didn't see, regardless of the fact. Because remember, we're saying that we seen the video. We did hear from the medical examiner. We heard from all that information. So, and we thought in our heads that they had enough, at least I did, without that honor K being in there. Why didn't they do it? Why didn't it go that way?
Yeah, I mean, the message that's sent is like, you can strangle your kid. You're good.
I think the only thing they asked for a definition of legal authority. That left me wondering, well, how do you unpack legal authority? It's right there. What are they asking? I wonder what they were asking about.
That, I think, was related to being able to control your child. Let me see. I had a note on that. When they asked that question, I had a note on that. What it was referring to. Give me just a second.
Gina, I seen you in the back. I don't know. Did you want to come up? I was gonna put you on stage just in a break of the conversation. You let me know if you want to come. If you want to come back in, we can have like 10 of us up here at a time. But yeah, I think that I just don't know if they were looking at the video, and that's what really concerns me, that there's some video or something that we.
So the legal authority question was about the allowance of him to use force on children. So it was about what that means in terms of legal authority in the discipline of your child.
Okay.
That's what they were asking about. And so what the Washington law says is that physical discipline of a child is not unlawful when it's reasonable and moderate, and is inflicted by a parent or guardian for purposes of restraining or correcting the child. So I don't know, the court, I'm assuming in instructions that was included in there, but I don't know. That's concerning that they have a question about legal authority to correct, and then seeing what the outcome of this was. I mean, did they view this as correction? And it says one of the things that's presumed unreasonable is interfering with the child's breathing.
How? What?
So,
No, say that again.
no, it says one of the presumed unreasonable disciplines, yes, is throwing, kicking, burning, cutting, striking, shaking, and interfering with a child's breathing is one. So, I mean, I don't know that they had this definition or not, but that's what they were asking about, is like, can this be considered like reasonable, I guess, discipline per the law?
Or do you think that
Do you need that really? I mean, like, let's use some common sense here. Like, you
Really?
choked your kid out till they passed out. That's not going to be listed as reasonable somewhere. Like,
so
I don't know.
With the instructions that it may have possibly confused them on that part, with them putting it in there? Only because I really don't like the way they did the instructions, and I'm like, if they're asking about these questions, clearly
Makes you want to go back and listen to them again.
Yeah, and yeah, unless you they have questions, and I know jurors, I mean, because I've never sat on the jury. Of course, I want to be the fourth person that does not know anything, but that's okay. As long as I'm not, you're not on trial, don't worry about it. But that's what I want to do if I ever get picked, right? But I guess my question would be, is like, when you get all these questions, you're not used to the process. If you haven't been a juror and you get all of this stuff and you're trying to finagle all of this, like, it seems like it can be very overwhelming. And although a judge may read all this stuff out, it's probably like womp womp womp. You get back there to the jury room, because like, they did your instructions. It was a pretty decent amount of time, and we can definitely replay them to kind of see how they were instructed, because maybe it's just the way they wrote the jury instructions out.
Can't see
that we're kind of working through that, because at the end of the day, regardless of all the other charges, I still feel like, I don't know, and y'all probably gonna be mad at me, because I think there's something that they did not see, because we saw the one video, right? And we can all agree that he was strangling her, right? I don't know about mom, but I'm just focusing on dad. We saw that. We saw how many people it took to take him off of her, right? That's the same. They did see that video. My question is just based off of that video, we were able to say, hey, he's guilty. What else did they see? They had to see something else. Like, it had to be something. Or you go tell me that the jury instructions is telling them that that's not with that, what you just said in regards to the restraint or punishment, that doesn't consider it. Just from that video alone. So that's why I'm worried that there was something else that we were not privy to, and something with the instructions that kept them from doing that second degree. And it may be reasonable for us to really listen to what those instructions were, because they have to follow the instructions, right?
Yeah.
I don't know. I'm just real concerned about. I mean, not to say that it makes any difference at this point in time from my point of view, but I just really, I think that it got to be something. Like it doesn't make sense if everybody else is seeing this, right? Mm.
I understand your point, but even given the even if they got the strangest instructions, like you must not take into consideration all her quailing in tears and her screams at the time, because we must be logical about this. Even given the strangest instructions, I cannot see how the jury could not just couldn't believe the evidence of their own senses, that we all saw the testimony, we all heard. Um, I read a lot from a person's voice and from their face. It's been said that there's no art to find the mind's construction in the face, but I disagree. I see all kinds of things. And in that man's face, I really regret that I couldn't hear his voice. But just looking at him, this is a man who has a really, really bad side in his eyes and the way he was restraining it, just the tightness around his mouth, just the way he was so guiltless, absolutely without any shred of remorse for what he had done. He looked absolutely justified. He felt absolutely justified in what he had done. Yeah, I saw absolutely no moral compunctions at all from him. From mom, yeah, she looked scared and she looked upset, but he just looked like he had done exactly as God meant him to do. He was a good father. He had only done what was allowed by the Quran.
And I get that, and that's why I keep bringing up, and I'm gonna keep hitting this on the head with everybody. We all seen the video, so you're right, exactly. No matter what the instructions were before they even got down to all the lesser charges or whatever, we had this second degree unaliving right there at the top, right? We all seen the video, and we was like, check mark, yes. What did they see, or what did they see that we didn't see that why wasn't that considered the degree unattempted unaliving? That's what I can't wrap around my head. I can't reconcile that in my head. Like I can't. Like something had to be you, right or no. I
Maybe
just
maybe if there's jurors watching, they'll contact you and you can ask them. We can ask them.
contact me. Yeah, even please, we would like to know, because I would like to really know, like, if there was something. Yeah, so any jurors that's out there, right?
Yeah, because we're trying to make sense out of something that isn't going to make any sense to us with what we know and what It's just there's not going to be any way to rationalize.
Yeah, it's just really it's really concerning to me, because the majority, I ain't gonna say the majority because I don't know how many people are really even tuning in. But when I look at the comments on the videos and stuff, like majority of the people can really sum up just from that video that this was an attempt to unalive his daughter. Then we put the medical testimony on top of it, right? So even if we just go off the information we have, which we know that, what else could have happened? What else did they have? What else did they see? Because I could have been able to convict them just based off the video. I wouldn't have needed all of the other information, because it would have just been a dad trying to survive his daughter, right? I wouldn't need to honor Kay, and I wouldn't need all of that. And I guess that's what I'm worried about.
Yeah.
And
I got to run. So I'm gonna let you two take over. But everybody who's just listening, if you can run over and just like this episode, that would be awesome. And thank you for letting me come on. Good to meet you, Colorado. Thank you.
Good to meet you.
Thank you, Greg. Yeah, so that's my biggest thing, is just trying to figure that part out. Like, what could they have seen? And I think that we should probably listen to the jury instructions again to kind of get an idea. Because I mean, I know I listened to it, but I was kind of like womp womp, same
Yeah,
old, right? It's the same old, same old. But I think that there had to be something different in regards to it, regarding what they, because we seen it, right? So it should have been a no brainer. That's what everybody thought, a no brainer. So I just really, yeah, I'm interested. Yeah. So if any jurors are out there and they're seeing us, yeah, send me an email so we can get you on here just to get a thought.
well, respect to her boyfriend who broke his hand trying to save her life. That's a hero. I, gosh, I hope they stay together. How romantic, you know? He tried to save her life. How many guys can say that?
Yeah, you got that right. Yeah, he definitely did. And all the kids that were out there, that it has to be a traumatic experience for all of them that were involved. Um, to see that and have to, especially for her.
It did my heart good to see a video for once where all these people rush to help, because I see so many where people just stroll by or they're just filming the whole thing. And that really scares me. But this reminds me that yes, people do care. You know, they're not just going to walk by. People look at the people who just dogpiled that and got involved and risked everything, you know, to rush right into that. That's the spirit I like to see.
Yeah. Yeah, it was nice to see that, and it didn't take for them to be adults. They were actually, teens that were trying to,
Hmm.
and do the right thing at that point in time. But I do hope that she's getting the therapy, because it's a lot to have to just deal with that part of it, right? Versus to even having to deal with not having, I see some people commenting in regards to she doesn't have any family and she's out here alone in the world. It's kind of, sometimes other families are better than your own family. So she'll probably be, hopefully she'll get some therapy, definitely, because that got to be very traumatic to know that your own parents and were trying to unalive you. Regardless if they were or not at this point in time, that is her mental state, and that's what she believes have happened. So she's gonna definitely need some therapy and stuff in regards to that.
There are organizations that exist to help girls exactly in her position, both here and in the UK. I don't remember what the one in the US is called, for people who are trying to, specifically, girls who are trying to escape arranged marriages or potential honor killings, but more generally, people who are trying to escape Islam, who are apostates, and therefore, by the Quran, it's legal to kill them unalive. I'm sorry. Okay. But if a whole organization exists just to help people who are trying to escape from another organization, that should kind of tell you something. They have this for Scientologists, Mormons, any kind of cult, Jehovah's Witnesses, all of them. But they especially have them for Islam, because they won't just criticize you or come after you financially. It's written into the Quran that if you quit Islam, it's a death sentence. So you can bet this is going to highlight that for a long time to come. And I can't wait to hear her interviews, to hear her side of the story when she's no longer restrained by her crushing emotions, or just the fact that she's, on trial.
You think she'll do interviews? I kind of don't want her to.
Well, if the money is there, every time an actor gets a paycheck, I applaud. But I think she. Imagine how much money she'll be offered. Imagine how much money people will offer her for the exclusive interview.
Well, I'm broke, so I can't offer her nothing. But look, I'm broke. I'm broke, so I can't offer him anything. But yeah, I definitely I want her to kind of, at least for a while, to kind of,
Yeah.
at least until she gets older, get secure, get some therapy, work through some things, and then be able to, because I don't know if this is truly what we think it is, right?
Well, she still needs to finish high school, right?
I think this is her last year. Yeah, I don't want her to be in danger or, anything like that if this is what it is, right? So I really would hope that, that's not the thing that she does really, really quickly. It's only for safety reasons. Anything else, unless they got her safety top notch, then yeah, I definitely agree with that. Yeah, so guys, anybody else want to come up? Because if not, we're going to rewatch some tests. I think we should go back and maybe listen to. We don't have to listen to all the instructions if y'all don't want to. I think we should listen to at least that. I think that was a good idea by Rachel by at least listening to what at least the dad's portion. Okay, Rachel says she thinks that the dad think the judge continued the protection orders against the daughter. Yeah. Hey, thanks for tuning in. Justice is the process. Oh, I've subscribed to that channel too. Oh, how sweet. Yeah, so I think that definitely look at that since we have questions about it, because I really just want to know what the jurors were sent back there with. They didn't ask a question about that one, right? So they only asked the question about the one that Rachel had brought up here. What's the possible sentence for dad? Hey, only fan, my only fan. I think that his was up to 5 years. Y'all can correct me if I'm wrong. I'm not particular. I know she wasn't letting him out. I think the mom was able to. I think she was probably able to leave yesterday. So she was like, she can't keep mom. Really, therapist for that one or for the unlawful imprisonment? Wait a minute. What's the possible sentence for that? Because he got 2 charges. He has the unlawful imprisonment and he has that 4th degree assault. Okay, 6 to 12 months for the false imprisonment and 364 days. I don't know, because I know he goes back for his actual sentencing on was it August the 18th? Okay. So what we're going to do right now is we are going to we'll look at the jury instructions and then we can come back. We can open the panel back up and discuss after we see and kind of go from there. How does that sound like a plan, guys?
I'm gonna.
Okay. So I'm gonna get the jury instructions pulled up. I'm gonna get the jury instructions pulled up. We'll look at those. We're not gonna go through the whole day of jury instructions. But I would like to just see because if y'all like me, I'm kind of like womp, 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 womp when we listening to the jury instructions. So it wouldn't be a bad idea for us to kind of like tune in and listen to them just so we can maybe get a little bit more clarity to see where the jurors were coming from in regards to this information. Okay. So give me a second here. I'm going to get that pulled up for us. Yeah, and welcome anybody that has dropped in, came by. Welcome, welcome, welcome. I appreciate the support. I appreciate your opinions. I appreciate that everybody is behaving, right? Y'all gonna earn a chair dance today. Boy, oh boy, oh boy. Well, I'm probably gonna give it to y'all. And I done found all y'all way. Yeah, so let's see here. I'm going to get that queued up for us, and then we're going to take a look at these jury instructions. Yeah, see what we can find that maybe with I'm really confused on how they didn't. I didn't need any of that other stuff. So I guess they probably glad glad that I wasn't the fourth person because y'all know I want to be the fourth person, right? I would have been back there like your vote don't count. This is what we about to do. Yeah, they probably don't want me back there. Like what we about to do. Yeah, this is what we about to do here. Let me see. Uh, jury instructions. Okay. So this is it's the closing arguments and jury instructions. We just gonna listen to a little bit of the jury instructions, at least more or less the stuff that applies today. I think would be a good bet for us. Let's see. Let me get that up here. Yeah, and that I tell you, our information with this old Colorado trial, then probably they done almost made me mad with that. Don't be sucking me halfway into no trial. And then telling me that and then have it up there and faking it. I almost want to blame them for clickbait. What y'all think about that? I'm like, I think they done clickbaited me. Let me see. I was getting into that trial, but what I will not do. And if y'all anything like me, what I will not do is I'm not gonna chase down no trial information. Getting all them clips from different places. That's not I can't do that one. That one I can't play with. Okay, so I got that queued up. So let's look at this a little bit. And we'll kind of go from there. And then we can open the panel up for discussion if anybody finds anything different or new with anything that they may have seen or heard when she's giving the jury instructions that may have made them decide in a different light that we think. That would be a good way. And then I'll break it up as we go along and give y'all chair dance. You know, you know, it's Friday, right? I was like, it's Freaky Friday, Frisky Friday, Friday. Oh no. Gina, you better get on it. You better get on it. Yeah, so is that kind of Friday, right? What Friday? But yeah, I done figured out how to put my music in the background so I don't get strike. And that way I can still like dance to a beat. Y'all don't know what beat I'm dancing to. I'll put the song in there and we'll all just get along, right? Ooh, wee. I'll tell you. Share. Yeah, so y'all got two me's, double P. Just for a little while. Okay, guys, here we go. We're going to listen. I don't take notes. Right, the Jews. Yeah, I was dancing to my own beat until I figured out I could play the music in the background. And I'm just going to put the name of whatever song I'm playing in the background in the chat. And I'm a mute and I'm a dance. That's what I'm going to do until I can figure out to get my own track. Once I get my own track, then we'll be in there. Okay, here you go, guys.
Read you the instructions, and I'm required to read them to you. Then we will begin closing arguments. We do anticipate that closing arguments will take all day today. And as I told you previously, we have ordered or are ordering lunch, and we anticipate probably about a 30-minute lunch break. And we will still have a recess in the morning and a recess in the afternoon, but those might only be about 10 minutes each. All right. These are the court's instructions.
Wait a minute. I don't know what happened right there. Hold on one second, guys. I have no clue what happened.
Between what you have in front of you and what I have in front of me. The originals, which I have, are signed by me and dated with today's date. And the original instructions and the original verdict forms are printed on white paper. Everything that you have is on blue paper. After I read you the instructions, and I'm required to read them to you, then we will begin closing arguments. We do anticipate that closing arguments will take all day today. And as I told you previously, we have ordered or are ordering lunch, and we anticipate probably about a 30-minute lunch break. And we will still have a recess in the morning and a recess in the afternoon, but those might only be about 10 minutes each. All right. These are the court's instructions to the jury. Instruction number 1. It is your duty to decide the facts in this case based upon the evidence presented to you during this trial. It is also your duty to accept the law from my instructions, regardless of what you personally believe the law is or what you personally think it should be. You must apply the law from my instructions to the facts that you decide have been proven, and in this way decide the case. Keep in mind that a charge is only an accusation. The filing of a charge is not evidence that the charge is true. Your decisions as jurors must be made solely upon the evidence presented during these proceedings. The evidence that you are to consider during your deliberations consists of the testimony that you have heard from witnesses and the exhibits that I have admitted during the trial. If evidence was not admitted or was stricken from the record, then you are not to consider it in reaching your verdict. Exhibits may have been marked by the court clerk and given a number, but they do not go with you to the jury room during your deliberations unless they have been admitted into evidence. The exhibits that have been admitted will be available to you in the jury room. One of my duties has been to rule on the admissibility of evidence. Do not be concerned during your deliberations about the reasons for my rulings on the evidence. If I have ruled that any evidence is inadmissible, or if I have asked you to disregard any evidence, then you must not discuss that evidence during your deliberations or consider it in reaching your verdict. Do not speculate whether the evidence would have favored one party or the other. In order to decide whether any proposition has been proved, you must consider all of the evidence that I have admitted that relates to the proposition. Each party is entitled to the benefit of all of the evidence, whether or not that party introduced it. You are the sole judges of the credibility of each witness. You are also the sole judges of the value or weight to be given to the testimony of each witness. In assessing credibility, you must avoid bias, conscious or unconscious, including bias based on religion, ethnicity, race, sexual orientation, gender, or disability. In considering a witness's testimony, you may consider these things: the opportunity of the witness to observe or know the things he or she testifies about, the ability of the witness to observe accurately, the quality of a witness's memory while testifying, the manner of the witness while testifying, any personal interest that a witness might have in the outcome or the issues, any bias or prejudice that the witness may have shown, the reasonableness of the witness's statements in the context of all the other evidence, and any other factors that affect your evaluation or belief of a witness or your evaluation of his or her testimony. The lawyer's remarks, statements, and arguments are intended to help you understand the evidence and apply the law. It is important, however, for you to remember that the lawyer's statements are not evidence. The evidence is the testimony and the exhibits. The law is contained in my instructions to you. You must disregard any remark, statement, or argument that is not supported by the evidence or the law in my instructions. You may have heard objections made by the lawyers during trial. Each party has the right to object to questions asked by another lawyer and may have a duty to do so. These objections should not influence you. Do not make any assumptions or draw any conclusions based on the lawyer's objections. Our state constitution prohibits a trial judge from making a comment on the evidence. It would be improper for me to express, by words or conduct, my personal opinion about the value of testimony or other evidence. I have not intentionally done this. If it appeared to you that I have indicated my personal opinion in any way, either during trial or in giving these instructions, you must disregard this entirely. You have nothing whatsoever to do with any punishment that may be imposed in case of a violation of the law. You may not consider the fact that punishment may follow conviction, except insofar as it may tend to make you careful. The order of these instructions has no significance as to their relative importance. They are all important. In closing arguments, the lawyers may properly discuss specific instructions. During your deliberations, you must consider the constructions as a whole. As jurors, you are officers of this court. You must not let your emotions overcome your rational thought process. You must reach your decision based on the facts proved to you and on the law given to you, not on sympathy, prejudice, or personal preference. To assure that all parties receive a fair trial, you must act impartially with an earnest desire to reach a proper verdict. Instruction number 2. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your own views and to change your opinion based upon further review of the evidence and these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors, nor should you change your mind just for the purpose of reaching a verdict. Instruction number 3. A separate crime is charged in each count. You must separately decide each count charged against each defendant. Your verdict on one count as to one defendant should not control your verdict on any other count or as to any other defendant. Instruction number 4. Each defendant has entered a plea of not guilty. That plea puts in issue every element of each crime charged. The state is the plaintiff and has the burden of proving each element of each crime beyond a reasonable doubt. The defendants have no burden of proving that a reasonable doubt exists as to any of these elements. The defendants are presumed innocent. This presumption continues throughout the entire trial unless during your deliberations you find it has been overcome by the evidence beyond a reasonable doubt. A reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. It is such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or lack of evidence. If from such consideration you have an abiding belief in the truth of the charge, you are satisfied beyond a reasonable doubt. Instruction number 5. The evidence that has been presented to you may be either direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who has directly perceived something at issue in this case. The term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in this case. The law does not distinguish between direct and circumstantial evidence in terms of their weight or value in finding the facts in this case. One is not necessarily more or less valuable than the other. Instruction number 6. A witness who has special training, education, or experience may be allowed to express an opinion in addition to giving testimony as to facts. You are not, however, required to accept his or her opinion. To determine the credibility and weight to be given to this type of evidence, you may consider, among other things, the education, training, experience, knowledge, and ability of the witness. You may also consider the reasons given for the opinion and the sources of his or her information, as well as considering the factors already given to you for evaluating the testimony of any other witness. Instruction number 7. A defendant is not required to testify. You may not use the fact that neither defendant has testified to infer guilt or to prejudice them in any way. Instruction number 8. You may consider a statement made out of court by one defendant as evidence against that defendant, but not as evidence against another defendant. Instruction number 9. A person commits the crime of murder in the second degree when with intent to cause the death of another person, but without premeditation, he or she causes the death of such person. Instruction number 10. A person commits the crime of attempted murder in the second degree when, with intent to commit that crime, he or she does any act that is a substantial step toward the commission of the crime. Instruction number 11. A substantial step is conduct that strongly indicates a criminal purpose and that is more than mere preparation. Instruction number 12. A person acts with intent or intentionally when acting with the objective or purpose to accomplish a result that constitutes a crime. Instruction number 13. A person is guilty of a crime if it is committed by the conduct of another person for which he or she is legally accountable. A person is legally accountable for the conduct of another person when he or she is an accomplice of such other person in the commission of the crime. A person is an accomplice in the commission of a crime if, with knowledge that it will promote or facilitate the commission of the crime, he or she either 1. Solicits, commands, encourages, or requests another person to commit the crime, or 2. Aids or agrees to aid another person in planning or committing the crime. The word aid means all assistance, whether given by words, acts, encouragement, support, or presence. A person who is present at the scene and ready to assist by his or her presence is aiding in the commission of the crime. However, more than mere presence and knowledge of the criminal activity of another must be shown to establish that a person present is an accomplice. A person who is an accomplice in the commission of a crime is guilty of that crime, whether present at the scene or not. Instruction number 14. The defendants are charged with attempted murder in the second degree. If the defendants were charged with the completed offense of murder in the second degree, the following elements would need to be proven beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant acted with intent to cause the death of Fatima Ali. 2. That Fatima Ali died as a result of the defendant's acts. And 3. That any of these acts occurred in the state of Washington.
Okay, I don't know if any of y'all are listening to these instructions. Did y'all hear that when she was mentioning in regards to the 3 things that they have to prove for this second degree attempt to unalive Fatima? Madison, I see your message. With the Montana case, I don't know what court TV stream is. They are the only network that was in the courtroom. What I would tell you is that it's like bits and pieces of the trial. after yesterday from day 2, I didn't see them go up with a live stream or anything for day 3. So I'm not sure if we are going to be able to actually cover it. And if you're a trial watcher, if you like, I'm sure you're a trial watcher, right? Because you're here, right? And that's what we do. If you know piecemealing testimony here, there, everywhere can be very frustrating. So I was like, I don't know if I have to let them get everything up there and we stream it or what. So that's what kind of happened with that one. And shout out to anybody that's in the chat room. Y'all see the links are dropped for Justice is a Process. Make sure you go over there and check it out. We have Broken Bear over his channel. Make sure you go check him out. And there's also Seeking Justice, right, on Discord. So yeah, please go support this community, right? Got different stuff going everywhere. I appreciate everybody for coming over. But yeah, I want to rewind that because I want y'all to hear that. Important. Here, listen.
Did with intent to cause the death of Fatima Ali. 2, that Fatima Ali died as a result of the defendant's acts. And 3, that any of these acts occurred in the state of Washington. Instruction.
Y'all know I'm ratchet. y'all know I'm terrible. I be reading fast. It's Broken Baker. Look, I'm so wrong. I'm so terrible. Y'all know I'm trying. Forgive me. I owe y'all a dance. It's cool. We'll be all right. Thank you so much. I appreciate it. Yeah, I could be a little rat. Like reading so fast and trying to do so much, and I don't want to miss anything or miss anyone. So y'all know. And if I ever, yeah. Back to the jury instructions.
Instruction number 15, to convict the defendant Ihsan Ali attempted murder in the second degree as set forth in count 1. Each of the following elements of the crime must be proved beyond a reasonable doubt.
Listen, this is in regards to the second degree unaliving. These are the 3 things that the jury had to check off in order to convict the dad of this. Please listen.
1, that on or about October 18, 2024, the defendant did an act that was a substantial step toward the commission of murder in the second degree. 2, that the act was done with the intent to commit murder in the second degree. And 3, that any of these acts occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 16, to convict the defendant Zahra Ali of the crime of attempted murder in the second degree as set forth in count 1. Each of the following elements of the crime must be proved beyond a reasonable doubt. 1, that on or about October 18, 2024, the defendant, as a principal or as an accomplice, did an act that was a substantial step toward the commission of murder in the second degree. 2, that the act was done with intent to commit murder in the second degree. And 3, that any of these acts occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 17. A person commits the crime of assault in the first degree when, with intent to inflict great bodily harm, he or she assaults another by any force or means likely to produce great bodily harm or death. Instruction number 18. An assault is an intentional touching or striking of another person that is harmful or offensive. A touching or striking is offensive if the touching or striking would offend an ordinary person who is not unduly sensitive. Instruction number 19. Great bodily harm means bodily injury that creates a probability of death or that causes significant serious permanent disfigurement or that causes a significant permanent loss or impairment of the function of any bodily part or organ. Instruction number 20. To convict the defendant Ihsan Ali crime of assault in the first degree as charged in count 2, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant assaulted Fatima Ali. 2. That the assault was committed by a force or means likely to produce great bodily harm or death. 3. That the defendant acted with intent to inflict great bodily harm. And 4. That this act occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 21. It is a defense to the charge of assault that the force used was lawful as defined in this instruction. The physical discipline of a child is lawful when it is reasonable and moderate and is inflicted by a parent for purposes of restraining or correcting the child. You must determine whether the force used, when viewed objectively, was reasonable and moderate. You may, but are not required to, infer that it is unreasonable to do the following acts to correct or restrain a child: throwing, kicking, burning, or cutting a child, striking a child with a closed fist, interfering with a child's breathing, doing any act that is likely to cause and that does cause bodily harm greater than transient pain or minor temporary marks. You shall consider the age, size, and condition of the child and the location of the injury when determining whether the bodily harm is reasonable or moderate. This inference is not binding on you, and it is for you to determine what weight, if any, such inference is to be given. The state bears the burden of proving beyond a reasonable doubt that the force used by the defendant was not lawful. If you find that the state has not proved the absence of this defense beyond a reasonable doubt, it will be your duty to return a verdict of not guilty as to this charge. Instruction number 22. The defendant is charged in count 2 with assault in the first degree. If, after full and careful deliberation on this charge, you are not satisfied beyond a reasonable doubt that the defendant is guilty, then you will consider whether the defendant is guilty of the lesser crime of assault in the second degree. If, after full and careful deliberation of the lesser charge of assault in the second degree, you are not satisfied beyond a reasonable doubt that the defendant is guilty, then you will consider whether the defendant is guilty of the lesser crime of assault in the fourth degree. When a crime has been proved against a person and there exists a reasonable doubt as to which of 2 or more degrees crime that person is guilty, he shall be convicted only of the lower degree. Instruction number 23. A person commits the crime of assault in the second degree when he or she intentionally assaults another and thereby recklessly inflicts substantial bodily harm or assaults another by strangulation. Instruction number 24. Strangulation means to compress a person's neck, thereby obstructing the person's blood flow or ability to breathe, or doing so with the intent to obstruct the person's blood flow or ability to breathe. Instruction number 25. A person is reckless or
So did y'all hear that in regards to this last instruction that we heard? This is the one that they actually were he was found guilty of, you notice in that instruction, it includes specifically strangulation. I'm gonna rewind it so you guys can hear it. I'm telling you, I really think it was these jury instructions, the way they were listed out.
Lower degree. Instruction number 23. A person commits the crime of assault in the second degree when he or she intentionally assaults another and thereby recklessly inflicts substantial bodily harm or assaults another by strangulation. Instruction number 24. Strangulation means to compress a person's neck, thereby obstructing the person's blood flow or ability to breathe, or doing so with the intent to obstruct the person's blood flow or ability to breathe. Instruction number 25. A person is reckless or acts recklessly when he or she knows of and disregards a substantial risk that a wrongful act may occur, and this disregard is a gross deviation from conduct that a reasonable person would exercise in the same situation. When recklessness as to a particular fact is required to establish an element of a crime, the element is also established if a person acts intentionally or knowingly as to that fact. Instruction number 26. Substantial bodily harm means bodily injury that involves a temporary but substantial disfigurement or that causes a temporary but substantial loss or impairment of the function of any bodily part or organ, or that causes a fracture of any bodily part. Instruction number 27. To convict the defendant Ihsan of the crime of assault in the second degree, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant A intentionally assaulted Fatima Ali and thereby recklessly inflicted substantial bodily harm, or B, intentionally assaulted Fatima Ali by strangulation, and 2, that this act occurred in the state of Washington. If you find from the evidence that element 2 and either alternative element 1A or 1B have been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. To return a verdict of guilty, the jury need not be unanimous as to which of alternatives 1A or 1B has been proved beyond a reasonable doubt, as long as each juror finds that either 1A or 1B has been proved beyond a reasonable doubt. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to either elements 1 or 2, then it will be your duty to return a verdict of not guilty. Instruction number 28. A person commits the crime of assault in the fourth degree when he commits an assault. Instruction number 29. To convict the defendant Ihsan Ali of the lesser included crime of assault in the fourth degree, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant intentionally assaulted Fatima Ali, and 2, that this act occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 30. To convict the defendant Zahra crime of assault in the second degree as charged in count 2, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant intentionally assaulted Fatima Ali by strangulation. And 2, that this act occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 31. A person commits the crime of unlawful imprisonment when he or she knowingly restrains the movements of another person in a manner that substantially interferes with the other person's liberty, if the restraint is without legal authority and without the other person's consent, and the person knows that the restraint is without legal authority and without the other person's consent. Instruction number 32. A person knows or acts knowingly or with knowledge with respect to a fact, circumstance, or result when he or she is aware of that fact, circumstance, or result. It is not necessary that the person know that the fact, circumstance, or result is defined by law as being unlawful or an element of a crime. If a person has information that would lead a reasonable person in the same situation to believe that a fact exists, the jury is permitted but not required to find that he or she acted with knowledge of that fact. When acting knowingly as to a particular fact is required to establish an element of a crime, the element is also established if a person acts intentionally as to that fact. Instruction number 33. Restraint is without consent if it is accomplished by physical force, intimidation, or deception. Instruction number 34. To convict the defendant Esau the crime of unlawful imprisonment as charged in count 3, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant knowingly restrained the movements of Fatima Ali in a manner that substantially interfered with her liberty. 2. That such restraint was without Fatima Ali's consent. 3. That the defendant knew that such restraint was without Fatima Ali's consent. 4. That such restraint was without legal authority. 5. That the defendant knew that such restraint was without legal authority. And 6. That any of these acts occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 35. To convict the defendant crime of unlawful imprisonment as charged in count 3, each of the following 6 elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant, as a principal or as an accomplice, knowingly restrained the movement of Fatima Ali in a manner that substantially interfered with her liberty. 2. That such restraint was without Fatima Ali's consent. 3. That the defendant knew that such restraint was without Fatima Ali's consent. 4. That such restraint was without legal authority. 5. That the defendant knew that such restraint was without legal authority. And 6. That any of these acts occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 36. Family or household member means a persons who have a biological or legal parent-child relationship, including step-parents and stepchildren and grandparents and grandchildren.
Okay, so now that we have heard the most important jury instructions, at least the ones that I can tell, does this change your mind in regards to how the jury reached their verdict? Do you think still that it sounds more like how the jury instructions were laid out. Yeah, Madison, that's yeah, it frustrated me, and I was like, I am not about to be bothered with that. The 13th juror, are you going to review the jury instructions all over again? No, I just wanted y'all to hear those important parts. It's totally up to y'all. Do anybody want to come up? Do they have any change of heart y'all want to discuss in the chat? Y'all let me know. You said no, Pretty Brown? So you think with the way the jury instructions were presented to the jury, I heard the same thing you heard, and I still don't understand how they came back with a not guilty verdict. I only question because when we were listening to the three things that they had to prove in regards to the second degree attempt to unalive, there were three conditions. If I'm not mistaken, one of those conditions really didn't, the way it was worded, maybe it don't seem like it applied beyond a reasonable doubt. You know, and it's so funny to me that when we're talking about the fourth degree assault, that in their jury instructions, they spell out strangulation. Right? So I think that's a big difference. That's why I'm asking. All right. So yeah, just thinking about that in that regards. That's why I'm saying it could be very confusing, right? Does anybody want to come up and talk about it? Got something to say? Let's discuss. Did anything change? Y'all want to put something in the chat? Y'all let me know. This I told y'all about the other little trial that we were thinking about covering.
Instruction number 37.
I mean, they got a whole bunch of come on, Libby. You gonna take a lunch break? You wanna take a lunch break? You gonna come talk to me? Gina says nowhere in oh, okay. Well, we don't do that. I'm not sure in regards to where you getting that at, Gina, if somebody has spread that or whatever the case may be, but we're not gonna be talking about those issues up there. We do want you up here. You don't want to come up here and talk about the verdict? So yeah, and Gina, when you're putting your stuff in the chat, we just want to remind everybody in regards to using the K word and the M word. I know we slip up all the time, right? It's in our vocabulary, but yeah, awesome. Yeah. Yeah. So if anybody wants to come up, I am going to drop the link in the chat. See if we can get somebody on here. It looks like we are going to have a new trial starting on Monday. We will see what that in details. Oh, you didn't follow this trial? What about any other trials that we watched, Libby? Or anybody else? It doesn't have to be about the Ali trial. Y'all know we've seen a whole bunch of verdicts this week, right? And some of them we was like, yep, check mark, right? Some was like check mark, yep. Like the one that we seen with the 5 shots. I took it and smiled. That one I think a lot of people had questions on. 13th juror says usually jury instructions are long and tedious. I think this jury got it right. I think that the jury did a tremendous job in evaluating the evidence. My question now is what happens to Fatima? I don't know, the 13th juror. I'm hoping that the Fatima is somewhere safe and moving on with her life, and it's just my assumptions, but I hopefully. Yeah, so I think he say, does she go to college? Does she? I don't think she marrying Isaiah. I don't think Isaiah family want no parts of that. No, they probably that daddy don't look like he want to be involved with none of that stuff that's going on, especially probably with the verdict, right? I didn't. I mean, I don't know, but yeah. So yeah, I don't know about that one, but it would be a fairy tale, right? Okay, let me get this together because I am gonna drop this. Yeah, well, like I said, for anybody, it doesn't have to be directly in regards to this one. If anybody wants to talk about any of the coverage or the trials that we have been streaming, any of the verdicts that we have seen, like we had so many verdicts this week, like it was ridiculous. Like one day verdict, one day verdict. Yeah, that's right. The 13th juror, she is an adult. I think she's still in high school. I think she in her last year. Yeah, that's what Colorado was saying when he came up here. I appreciate him coming up here and voicing his opinion. Very respectfully, him and Rachel earlier today. That she'll probably do some interviews because of the money and things of that nature. You said we need a weekly recap of what was accomplished. My brain is remember it all. Me neither. Uh, Here, I'm dropping the link. Give me 1 second. Give me 1 second, and we can. I'll try to give y'all a recap. Shoot, we've been all over the place. Y'all know that's the one thing about when you going all over the place and you've been all over. The trials start to merge together. Here, I'm gonna put this on just for. I mean, we even got some DB in this week. Like we was able to listen to our boy Daryl Brooks. I know I seen a clip last night from Law and Crime, and I was like, "Oh, I gotta show this." Okay, here we go. I'm just gonna put this on just for a second. Give me a I was saying I'll be right back. I'm gonna go get some water and then we'll do a recap. And if anybody wants to come up, just go ahead and click the link and we can talk about it and have our panels. I really like doing the panel, so it'd be nice if, you guys, you know, I mean, we all family. You can come in your rollers. You ain't got to have all your makeup on. Just don't be driving. And we good, right? And I'll be more than happy to have you guys up here, right? It's nice to put a face with the people that's in the chat, and yeah. Okay, give me 1 second. Let me go get some water.
It is a defense to a charge of assault in the 4th degree as charged in count 4 as to Ihsan Ali that the force used was lawful as defined in this instruction. Use of force upon or toward the person of another is lawful when used by a person who reasonably believes that he is about to be injured in preventing or attempting to prevent an offense against the person, and when the force is not more than is necessary. The person using the force may employ such force and means as a reasonably prudent person would use under the same or similar conditions as they appeared to the person, taking into consideration all of the facts and circumstances known to the person at the time of and prior to the incident. The state has the burden of proving beyond a reasonable doubt that the force used by the defendant was not lawful. If you find that the state has not proved the absence of this defense beyond a reasonable doubt, then it will be your duty to return a verdict of not guilty as to this charge. Instruction number 38. Necessary means that under the circumstances as they reasonably appeared to the actor at the time, 1, no reasonably effective alternative to the use of force appeared to exist, and 2, the amount of force used was reasonable to effect the lawful purpose intended. Instruction number 39. It is lawful for a person who is in a place where that person has a right to be and who has reasonable grounds for believing that he is being attacked to stand his ground and defend against such attack by the use of lawful force. The law does not impose a duty to retreat. Notwithstanding the requirement that lawful force may be not more than is necessary, the law does not impose a duty to retreat. Retreat should not be considered by you as a reasonably effective alternative. Instruction number 40. No person may, by an intentional act reasonably likely to provoke a belligerent response, create a necessity for acting in self-defense, and thereupon use or attempt to use force upon or toward another person. Therefore, if you find beyond a reasonable doubt that the defendant was the aggressor and that the defendant's acts and conduct provoked or commenced the fight, then self-defense is not available as a defense. Instruction number 41. To convict the defendant Ihsan Ali of the crime of assault in the 4th degree as charged in count 4, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant assaulted Isaiah Williams. This act occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 42. A person commits the crime of burglary in the 2nd degree when he or she enters or remains unlawfully in a building with intent to commit a crime against a person or property therein. Instruction number 43. A person enters or remains unlawfully in or upon premises when she is not then licensed, invited, or otherwise privileged to so enter or remain. A license or privilege to enter or remain in a building that is only partly open to the public is not a license or privilege to enter or remain in that part of the building that is not open to the public. Instruction number 44. A person who enters or remains unlawfully in a building may be inferred to have acted with intent to commit a crime against a person or property therein. This inference is not binding upon you and is and it is for you to determine what weight, if any, such inference is to be given. Instruction number 45. The term premises.
Okay. So I didn't see anybody come up here in the chat. I don't see nobody that's no fearless people that want to talk about all these verdicts. Let's see here. So I will go into a recap of what we saw all this week as far as our trials that we covered. The first one I'll start with is we didn't cover the full trial, but we did do the verdict. So for anybody that had any questions, they didn't have live camera feed in the courtroom for this one. But we are going to just go through our weekly recap, right? Because we definitely had a week. I think this is the first week that we actually there's nobody in court, or there's no live feed or no streaming inside the court for us. Weird, huh? But Monday we kick off and it's gonna be something different, right? There's always something. Where my Florida people at? Y'all know y'all be doing the most. They are not gonna let us down. If don't nobody else, Florida will get up in here because they say they gonna be on court TV, crime live. They're gonna be in long crime. They're gonna be on live 35. They are gonna have something going on. So I'm gonna start off with our first verdict. I kind of got them, some of them clipped up. So here we go.
On a reasonable doubt, find the defendant, James Craig, guilty of solicitation to commit perjury in the first degree. As to verdict form count 7, manslaughter, cause or aid suicide, we, the jury, find the defendant, James Craig, not guilty of manslaughter, cause or aid suicide. Let me then turn to the foreperson and ask, is this the verdict of the jury? Do all of you agree with this verdict?
Yes.
At this point in time, you can be seated. Let me ask then if either party wishes to have the jury pulled from the people.
No, Your Honor.
From the defense? Yes. Ladies and gentlemen of the jury, I'm going to, just for, so that you are aware, the court is going to be asking if this is in fact your verdict. I'm going to use first names with your last initial, just so that you are clear, so that you understand what you're looking for when it's your turn then to respond to the court's question.
So that's our first verdict, guilty, right? That's the first one that we got up here where they were found guilty real quickly. Here's our second one that we did. Stream at there also. So if you guys are hearing me, that's what's currently going on. So
Ready for the jury meeting? Please be seated in the courtroom. Okay, members of the jury, we received notice you have a verdict. Is that correct? Could I have the presiding juror stand momentarily? Is that verdict unanimous, sir? Yes, sir. Okay, could you hand it to the bailiff for me and you can be seated? Could I have defendant and counsel rise? State of Texas versus Billy Delgado. We, the jury, find the defendant, Billy Delgado, guilty of aggravated assault causing serious bodily injury with a deadly weapon to a family member, felony of first degree, signed by the presiding juror. You wish to have them polled?
Yes, sir.
Do they know their numbers or not? Do they know their numbers? Okay, could I have the list, jury list? Thank you. Okay, when I call your last name, ladies and gentlemen, the question is whether that is your verdict and you join in that verdict. If you do, say yes. If you don't for any reason, please say no. Nieta?
Yes. May I please support? Ladies and gentlemen of the jury, first I want to thank you. Thank you for executing your civic duty, and thank you on behalf of the District Attorney's Office and on behalf of Mr. Evans. Now, the law is going to ask you.
There's our second one. Guilty. Sentenced to 50 years. Let me get our third one up here.
Guilty of second-degree murder and manslaughter.
Instruction.
None from the state. No objection from the state.
All right.
Circumstances around it that show. Yes.
We covered this trial all in one day, so
Mr. Defendant, statement instruction.
I didn't take the video. I didn't clip this video for the verdict. I just kept it all together because all the testimony, everything, jury instructions, closing arguments, everything was in one nice little thing.
Common sense, you'll see.
Hmm.
All right, have a seat. All right, does the defense wish to present a case? I will make sure you get the menus for them. Once you get the menus, go home for the night. We'll see you back.
He lays his head.
Opening argument, he may make.
I don't know.
Juror number
But I want
484, is this your true and accurate verdict?
Yes.
Juror number 693, is this your true and accurate verdict?
and then we had our queso. And Scotty. What the daddy snitching on what the daddy is snitching on somebody?
Since you'll see that this
Snitching
defendant
on son.
wasn't acting like a reasonably
Bill,
prudent
did
person.
you say you wanted to watch that? Oh, what's all the ones for? I missed it. I'm just looking back at the chat. One. I don't know what the please don't spam the chat. What's the ones for? Queso, menus, Jason out here working on back. Is that Zach working on Jason? It's the back and shoulders day. Okay, they working on biceps, triceps, and okay.
And at that.
And then we know we had the Ali yesterday, but
Would you please state your name for the record, sir?
Abdul Robinson, Senior.
Please stay close to the microphone and your waist up. Do you have any nicknames?
Yes, Blue.
And how old are you today?
54.
You have any children?
Yes.
How many?
I have 11 children.
What's the age of your oldest child?
34.
And your youngest?
6.
Prior to getting arrested, did you have a good relationship with all of your children?
Yes.
And are you currently incarcerated on a number of felony charges?
Yes.
On 2 separate cases?
Yes.
When were you arrested and taken into custody?
September 10th, 2020.
And have you remained incarcerated since your arrest?
Yes.
Have you been charged by the state with accessory after the fact to first-degree murder and solicitation to commit first-degree murder related to the murder of Damon Rothermel?
Yes.
And when did that murder take place?
I think on January 31st, 2019.
And there was the potential for you to be charged as a principal in that murder, is that correct?
Yes.
But you weren't.
No.
And do you have co-defendants who have been charged with the murder of Damon Rothermel?
Yes.
And who are they?
Christopher Brown, Derek Hudson, Dominique Warner.
And so you know who all three of those individuals are.
Yes,
Have you also been charged by the state with accessory after the fact to commit first-degree murder related to the murder of Charles McCormick?
yes,
And did that murder take place on January 15th of 2020?
yes,
Are Hakeem Robinson, Abdul Robinson Jr., Leroy Whitaker, and Dominique Barner also charged with the murder of Charles McCormick?
yes.
How are you related to Abdul Robinson Jr. and Hakeem Robinson?
Their father.
They have the same mother?
No.
Who's Abdul Robinson Jr.'s mother?
Angela London.
And what about Hakeem Robinson?
Ebony Walters.
Who's older between Abdul Jr. and Hakeem?
Abdul Jr.
How much older?
About 4 years.
Do you recall what Abdul Robinson Jr.'s birthday is?
Yes.
What is it?
November 9th, 94.
And what about Hakeem Robinson?
November 9th, 98.
So same day, just 4 years apart.
Yes.
Does Abdul Jr. have any nicknames?
Yes.
And what are they?
Little Blue. Crazy K.
Does he also go by his middle name sometimes?
Kareem.
Does Hakeem Robinson have any nicknames?
Yes.
What are they?
Keeman. Queso.
What's the Queso nickname for?
It's an entertainment name.
The rap name?
Yes, rap name.
Now, prior to getting arrested, who was Abdul Robinson Jr. living with?
With me?
And for about how long had he been living with you?
About 10 years.
And what about Hakeem Robinson? Where was he living?
He was living with me.
In January of 2020, were you, Abdul Robinson Jr., and Hakeem Robinson all living on Brown Jersey Court?
Yes.
Is that in the Ocean Way area?
Yes.
Prior to living in that home, what area of town were y'all living in?
West Side, Norman area.
Normandy? Do you know a person named Leroy Whitaker?
Yes.
Are Hakeem Robinson and Leroy Whitaker related to one another?
Yes.
How so?
Cousins.
Okay. And what's the family connection?
Mother and father and mother, brother and sisters.
So is that Leroy Whitaker's father and Hakeem Robinson's mother?
Yes.
Now, over the years, kind of leading up to 2020, did Hakeem Robinson and Leroy Whitaker have a close relationship?
Yes.
Does Leroy Whitaker have a nickname?
Yes.
And what is it?
Scotty.
Mr. Robinson, do you see your son Hakeem Robinson in the courtroom here today?
Yes.
Can you tell us where he's seated and what he is wearing?
He's seated between these two lawyers right there with a beige suit on.
Your Honor, the record reflect the witness has identified Mr. Hakeem Robinson.
Okay, the record shall so reflect.
And do you also see Leroy Whitaker in the courtroom here today?
Yes.
Can you tell us where he's seated and what he's wearing?
He's wearing a gray suit, sitting right next to his lawyer.
Is that which table?
Front table.
Your Honor, the record will reflect.
All right, the record shall so reflect.
You also know someone by the name of Dominique Barner.
Yes.
Is Dominique Barner related to your family?
Nope.
Were you friends with Dominique Barner's father?
Yes.
So how long would you say you've known Dominique Barner?
Most all his life.
Does Dominique Barner have a nickname?
Yes.
What is it?
Butter?
And do you know why he has that nickname?
No, I don't know why I have it.
Now, prior to getting arrested, was Dominique Barner friends with Abdul Robinson Jr.?
Yes.
Did he also spend time with Hakeem Robinson?
Yes.
Now, on April 11th of 22, did you enter pleas of guilty to the court in both of your pending cases?
Yes, I did.
And was that plea partially negotiated with the state?
Yes.
Now, as part of your plea, you agreed to cooperate against the co-defendants in both cases?
Yes.
Have you been sentenced yet on either of your charges?
No, I haven't.
Who ultimately will decide what sentence you get?
From my understanding, the judge.
And what judge did you enter a plea guilty to?
Miss Salvador.
Now, in the Damon Rothermel murder case, where you pled to accessory after the fact, is that right?
Yes.
And based on that plea, when you were sentenced by the judge, did the state agree that we will drop the solicitation to commit murder charge?
Yes.
Is both the accessory after the fact and the solicitation a first-degree felony?
Yes.
So they're both punishable by 30 years.
Yes.
And in the Charles McCormick murder case, you also pled to accessory after the fact, a first-degree felony.
Yes.
All right, and typically first-degree felony punishable by up to 30 years. Is that correct?
Yes.
Now, as part of your pleas, did the state agree to cap the maximum sentence you could receive to be 20 years?
Yes.
Now, if you are to receive a 20-year sentence from the court, how old would you be approximately at the end of that sentence?
Say that again.
If you were to be sentenced to 20 years by the court, at the end of that sentence, approximately how old would you be?
I'll be close to 70.
And as part of your plea, did you have sentencing guidelines in your case
Yes.
that represent the lowest sentence the court should sentence you to, absent a legal reason to go below?
Yes.
And what were your guidelines in your case? Do you recall?
76 months to 20 years.
Now, even though cooperation provides a legal basis that allows the court to go below, does the court have to?
No.
Does the court have to follow any recommendation the state makes?
No.
And sitting here, do you have any idea what sentence you're going to get?
Nope.
Are you hoping for the best sentence you can get?
Yes.
Did the state of Florida at any time promise you that we would recommend any specific sentence?
No.
On January 15, 2020, prior to the murder of Charles McCormick, were you aware of what was going to happen to him that day?
No.
Did you participate in any of the planning of the murder of Charles McCormick?
No.
Were you present when Charles McCormick was murdered?
No.
Did you know that was going to happen before it happened?
Nope.
When did you find out Charles McCormick was going to be murdered? Or, excuse me, when did you find out Charles McCormick had been murdered?
After I picked up Scott and Butter.
So that would be Leroy Whitaker and Dominique Barner?
Yes.
You indicated you picked them up. How did you know that they needed a ride on January 15, 2020?
My son called me and asked me to go give Scotty a ride.
Which son?
Kareem.
Abdul Jr.?
Yes.
Do you recall what Abdul Jr.'s phone number was that he communicated with you on that day?
I think it's 904 624 3694 84.
3684?
Yeah.
Do you recall what your phone number was back on January 15, 2020?
904 866 2370.
Now, sitting here today, you realize that you are testifying against not only co-defendants, but family members.
Yes.
Why are you doing that?
I have a number of reasons.
And what are they?
I got some health issues. I got 2 6-year-olds and an 8-year-old daughter. And, when my 8-year-old daughter asked me when I'm going to come take her to the daddy-daughter dance.
Objection, hearsay relevance.
Overruled.
You can answer.
When she asked me over each year when I'm going to come take her there, and I keep letting her down. Then my 6-year-old son, when he asked me if I'm going to come to his football games, come take him fishing. My other 6-year-old, he asked me, when I'm going to come see him, when he begging me, please come see me, daddy. He want to teach me how to play the game, but he don't know where I'm at. You know, things like that. My health issues.
What health issues do you have?
I have diabetic. I'm diabetic. I'm on high blood pressure. I suffer from congestive heart failure. I just found out June 25th that my kidneys is failing rapidly.
Has becoming a witness in this case negatively impacted your relationship with your entire family?
Well, I really don't have no more relationship with my family besides one person.
So a part of your family completely cut you out?
Yeah.
When people know that you're cooperating, does that make it easier or harder for you when you're incarcerated?
Well, it make it harder for me.
What about when you get out?
Extremely harder.
Is cooperating in this case something that is easy for you to do?
No, this is the most hardest decision I've had to make in my life.
The day that Charles McCormick was murdered on January 15, 2020, does that specific day hold any significance for you and your family?
Yes.
And why is that date significant in your mind?
It's the date that my son got killed.
Who was your son that got killed?
Willie Addison.
Is he your biological child?
No.
Do you still consider him to be your son?
Yes, I consider him to be my son.
Did Willie Addison have a nickname?
Yes.
What was that?
Lil Willie, Boss Goon.
Who was Willie Addison's mother?
Angie Lundy.
Same as Abdul Jr.?
Yeah.
What was the age difference between Willie and Abdul Jr.?
I think about 2 years.
Before Willie Addison was killed on January 15, 2019, where was he living?
He was living with me.
And what area of town was that?
Normandy, off Normandy.
Who else was living there at the time?
Hakeem, my daughter, and Abdul Jr.
Were Abdul Jr. and Hakeem Robinson close to Willie?
Yes.
How close would you consider him?
It was pretty close.
Did they be brothers?
Yes.
Where was Willie Addison when he was actually shot on January 15, 2019?
He was in the truck with me in the passenger seat.
Were you driving?
Yes.
And so Willie was in the front passenger seat?
Yes.
Was anyone else in the vehicle?
It was like 4 more people in the vehicle.
Who were they?
Abdul Jr., Moody, my nephew, Samuel, and Pooh Red.
Is Pooh Red Torgon Williams?
Yes.
Is Torgon Williams related?
Yes.
How so?
Cousin.
Now, did Torgon and Willie have a decent relationship?
I think it was okay.
Was Torgon Williams close to your son Abdul Robinson Jr.?
Yes.
How was Torgon's relationship with Hakeem Robinson?
Well, they had a pretty good relationship.
Now, when Willie Addison was shot, was anyone else inside the vehicle hurt as well?
Everybody.
Including you?
Yes.
After everyone was shot, what did you do?
Well, I drove to the hospital, and as I was driving, I could, hear Willie making this guggling noise, and I hold his hand while I was driving, because I didn't want him to feel like he died alone. And I drove to Memorial Hospital, and when we got to the hospital, I got everybody out the car while I was shot and helped everybody get, inside the hospital, because it was like people at the hospital really didn't want to help us.
Where were you shot?
In the back.
Where in the vehicle was Abdul Jr. seated?
In the middle row.
Was he shot?
Yes,
Where was Abdul Jr. shot?
in the head.
Did he almost die?
Yes, I think he did die, but he, came back.
What about your nephew? You said Sammy. Is he hurt?
Yeah.
How was he hurt?
Oh, he got shot about 7 times. He's paralyzed right now.
And Torgon was shot
Yes,
multiple times.
yes.
How long did Abdul Jr., since he was shot in the head, how long did he remain in the hospital?
He stayed in the hospital about 3 or 4 months.
After Abdul Jr. got out of the hospital, was he still physically affected by his injuries?
Yes, he had to learn how to, he had to basically learn how to do everything all over again.
Walk again?
Walk again, talk again, everything. We had to go to Brooks therapy.
Did you help Abdul Jr. as he recovered?
Yes, I did.
Was Abdul Jr. Affected mentally by the shooting?
Yes.
Also,
I think it made him more, more angry. Like, I don't know if bipolar like was be the right word to use, but it made him it changed his mood swing.
now Hakeem Robinson was not in the vehicle when the shooting happened, correct?
No.
How was he affected mentally by Abdul Jr. and his family members being hurt?
Objection, speculation, personal knowledge.
Yeah, unless he has personal knowledge, I'll sustain that objection.
Do you have personal knowledge as to how Hakeem Robinson was feeling after this happened?
Yeah.
Is that because he was living with you?
Yes.
How was Hakeem Robinson after this?
I mean, he was angry about it. I mean, we was all angry about it.
To the best of your knowledge, was Charles McCormick involved in the shooting of Willie Addison or anyone else in that vehicle, personally?
No.
After Willie Addison was killed, did Charles McCormick put out a song that personally upset you and your family?
Yes.
And what's a diss song or a diss track?
Oh, it's when you talk about somebody, somebody's dead.
Is that what Charles McCormick's song did?
Yes.
And who did it reference that upset you and your family?
He talked about Willie.
How did you find out about that song?
On social media.
Did you personally find it or did someone point it out to you?
No, my son showed it to me.
Which one?
Both of them.
And that would be
Kareem and Hakeem.
Abdul Jr. and Hakeem Robinson?
Yes.
Did Abdul Jr. or Hakeem Robinson, either one, talk about the song?
I mean, yeah, they didn't like it.
Are you familiar with a local rap group known as ATK?
Yes.
Do you consider yourself to be a member of ATK?
No.
Is Abdul Robinson Jr. part of ATK?
Yeah.
What about Hakeem Robinson?
Yes.
Leroy Whitaker?
Yes.
Torgon Williams?
Yeah.
And is Dominic Barner affiliated with members of ATK?
Yeah.
Was Charles McCormick part of ATK?
No.
Who was Charles McCormick affiliated with?
6 Block.
All right. Another local rap group here?
Yes.
Did Charles McCormick have a rap name or a nickname that you're aware of?
Yeah.
All right, and what was that?
Little Buck.
How would you describe the relationship between the group 6 Block and the group ATK?
They didn't like each other.
Did they get along?
No.
Do they consider one another to be ops?
Yes.
Who do you know that had a desire to go after Charles McCormick based on that song?
I mean, I would say a few people.
All right. Anybody related to you or anyone else?
Yeah.
All right. Well, who would you think had the most?
The most? I would say Abdul, my son, both of them, Hakeem and Abdul.
In January of 2020, did Abdul Jr. Own his own vehicle?
No.
How did he get around?
Well, rent a car.
Do you recall if on January 15th of 2020, Abdul Jr. had a rental car?
Yes.
What kind did he have?
A Dodge Journey.
Did both Abdul Jr. and Hakeem Robinson travel in rental cars?
Yes.
Did you own a car on January 15th, 2020?
Yes.
What kind?
Dodge Challenger.
What color was it?
Like reddish orange.
And the phone that you had on January 15th, 2020, what type of phone was it?
An iPhone.
And I think you said earlier, but 904-866-2370, was that your number?
Yes.
Who was your cell carrier?
T-Mobile.
Was that account under your name, Abdul Robinson Sr.?
No.
What name was it under?
Daryl Watts.
Who was Daryl Watts?
A friend of mine.
Is he deceased?
Yes.
So why was your phone under an account with that name?
Well, we went to get them together. His credit was a little better than mine.
So did you maintain your phone under that account after he passed?
Yes, I was an authorized user.
Did Abdul Robinson Jr. have a cell phone in January 2020?
Yes.
Did he have just one?
No, he had a couple of phones.
Why do you have a couple phones?
I mean, you got, your work phone, your phone for your ladies, or something like that, different phones.
What was Abdul Jr.'s primary number back in January 2020? Was that the 624-3684 you mentioned?
Yes.
Is that the number you typically would communicate with him on?
Yes.
Did he have a second phone number that you helped get it?
Yes.
Do you recall what that number was?
I think the area code was 478-491-2831.
And how do you know that was a number that Abdul Jr. was using?
I got the phone for him.
Was that put up under the Daryl Watts account name?
Yes.
Do you recall when that was done approximately?
I know it was, I think it was like November. In November, I think it's like the November 12th or the 15th.
So sometime in November?
Yes.
Would that be 2019?
Yes.
Did Hakeem Robinson own a cell phone in January 2020?
Yes.
Did he have just one phone?
He had a couple phones.
What type of phones did he have?
iPhone.
And what was Hakeem Robinson's primary number back in January 2020 that you would communicate with him on?
The phone number?
Yes, sir.
904 704, I think 1595.
And was that phone number under the Daryl Watts account?
No.
What account was that phone number under?
I don't know. I think his mother got that phone for him.
Miss Walters?
Yes.
Do you recognize phone number 478-305-9583?
Yes.
Whose phone number was that in January 2020?
Hakeem?
Hakeem Robinson's?
Yes.
And how do you know that?
I got it for him.
Was that up under the Daryl Watts account as well?
Yes.
Objection leading on this whole line of questioning.
Well, I'll address the last question, and that's overruled.
Was the 478-305-9583 number you just mentioned, was that activated on the same day as the one you got for Abdul Jr.?
Yes.
And did you at times pay that bill for them?
Yeah.
In January 2020, did Leroy Whitaker have a cell phone?
Yes.
Do you ever communicate with him on his cell phone?
Yes.
Do you recall what his phone number was at the time?
904 803. I think 3671.
Now, turning your attention back specifically to January 15, 2020, did you get asked for help that day?
Yes.
And how did you get asked for help?
Well, I was asked to give somebody a ride, Scotty a ride.
And who asked you specifically?
Abdul Jr.
And how did he get in touch with you to ask you that?
He called me.
Did he call you one time or more than once, if you recall?
I think he called me more than once.
When you spoke to Abdul Jr., did he tell you why Leroy Whitaker needed a ride?
No.
Do you know what area of town or Leroy Whitaker was in that you needed to go pick him up?
Say that again.
How did you know where to go pick Leroy Whitaker up?
Abdul Jr., he sent me a pin drop, a location.
What area of town did that take you to?
Arlington.
Was it a business area, a residential neighborhood?
Residential area.
When you went to pick Leroy Whitaker up, what were you driving?
Dodge Challenger.
And you had your phone number, the 866-2370 number with you?
Yes.
When you drove that Dodge Challenger over there, is that a car that's actually in your name?
Yes.
Prior to picking Leroy Whitaker up that day, did you ever speak to him on the phone?
Yes.
You get any information from him as well?
Yes. I called him and I think the location thing took me past the location, and I called him, asked him where he was at, and he told me what house he was in. What it was a car in the yard, a certain car. I can't remember what the car was though.
Do you recall what the name of the road was where you actually went?
On Townsend.
When you were driving on Townsend, did you see any police in the area?
Yes, I seen one police.
Where was that?
Say that again.
Where was that? Where did you see the police?
It was about a block or two from where I picked him up from.
Now, when you got to the correct location, what did you do?
Well, I pulled in the yard and I called Scotty, asked him, where they was at.
Now, you said you pulled into the yard. What was at that location? Was that a home?
Yes, it was to the house.
Did you recognize that home?
No.
Did you have any idea who was living there?
No, I didn't.
Did Leroy Whitaker come out immediately?
No.
As you waited, did you reach out to anyone?
I reached out to Scotty, and I got a little impatient, and I just asked him like where he at when he coming. He told me they was coming.
Did you reach out to anybody else?
Yes, I called my son, Abdul.
What was the purpose of contacting your son, Abdul Jr.?
I just wanted to know where they was at, what was taking so long.
Do you recall if that was a phone call or a communication by a message? Do you have any idea? I know it was 5 years ago.
I can't quite remember.
Eventually, did Leroy Whitaker come out of the home?
Yes.
Was he by himself?
No.
Who was with him?
Butter.
And when Leroy Whitaker and Butter, Dominique Barner?
Yes.
When they both came out, how were they acting? How were they walking?
I mean, I would say a little urgent.
Do you recall what either one of them was wearing?
Yes, they had on some pajamas.
Do you remember any details about the pajamas?
Some Mountain Dew pajamas.
Did that look like clothes that you typically would see Leroy Whitaker or Dominic Barner in?
No.
Once they came out, did you let them into your car?
Say that again?
Did you let them both into your vehicle? After they got in, what direction did you drive towards?
Towards Arlington Expressway.
And were there still police in the area?
Well, I only seen that one.
Now, as you were driving away, did you ask them or were you concerned about anybody in particular?
Yes.
Who?
Hakeem.
And why were you concerned for Hakeem?
I know that's his circle of friends.
Was it unusual in your mind for him not to be with them at that point?
Yeah.
Now, as you were driving Leroy Whitaker and Dominic Barner away, did you find out what had happened to Charles McCormick?
Yes.
And you found out the details about who was involved?
Yes.
And did you continue to drive both Leroy Whitaker and Dominic Barner away?
Yes.
And after getting away from that neighborhood, did you make a stop?
Yes.
And where did you stop?
We stopped in Grand Park.
And what was the reason of stopping in that area?
Switch cars.
And were you able to do that?
Yes.
What car did you switch out of?
We got in a white Impala.
Who did the white Impala belong to?
It was my daughter's car, but it was in my name.
Why did you want to switch out of your Dodge Challenger?
After I found out what happened, we in an orange car, very noticeable.
Did you eventually make it back to your home?
Yes.
And again, that's on Brown Jersey Court.
Yes.
Do you recall around what time of day it was that you made it back to that location, approximately?
I can't say the exact time. It's like I can't say the exact time, maybe like 2:30 something up,
Do it in the afternoon.
Yes.
After you got back to your home, did you do anything else to assist either Leroy Whitaker or Dominic Barner?
Yes.
What did you do?
Well, I took the clothes they had on and left with them.
Where'd you go?
I went over there off Kings Road behind Burger King, put them in this fire barrel.
Did you set them on fire?
Yes.
And why were you doing that?
It was just my way to help.
Did you take either Leroy Whitaker or Dominic Barner with you when you did that?
No.
Do you recall if anyone else was at your home prior to you leaving to set those clothes on fire?
No.
No, there weren't, or no, you don't recall?
No, I don't recall nobody though.
Did you return to Brown Jersey Court that night?
I can't remember.
Are you familiar with an address 2203 West 12th Street?
Yes.
And why are you familiar with that specific address?
That's been my address. That's my grandma's address.
Has that house been or stayed in the Robinson family?
Yes.
Are you also familiar with the name House of Pain?
Yes.
Who came up with that name?
I did.
When was that?
It's back in the 90s.
What did you want to use the House of Pain name for?
Entertainment.
Is that a name that is still kind of used by the Robinsons?
Yeah.
Your family? Was Hakeem Robinson aware of that name, House of Pain?
Yeah.
Did Hakeem Robinson have an Instagram account that he was using back in January of 2020?
Yes.
Do you recall what his Instagram account name was?
It was queso 23 times.
What about Abdul Jr.? Did he have an Instagram account?
Yes.
What was that?
K Crazy.
Do you know someone by the name of Shifan Hogan?
Yes.
Who is he?
That's my baby mother's brother.
Are you also aware of a music video called Bang It Out?
Yes.
And whose music video is that?
Hakeem?
Do you know where that was filmed?
Yes.
Where?
Downtown by the Chop House.
Were you there when it was filmed?
Yes.
Was it filmed prior to Charles McCormick's murder?
Yes.
Your Honor, may I publish some items that are already in evidence?
Okay.
Showing you what's in evidence is State's Exhibit 191 on the monitor in front of you. You see that? Should be on the monitor right here.
Oh, yeah.
Did you see that vehicle?
Yes.
That your red Dodge Challenger that you were driving on January 15, 2020?
Yes.
This is State's 193.
They call me Queso.
Sir, in that video, the two firearms that Akeem Robinson was holding, do you recognize those?
Yes.
Whose firearms who do they belong to?
Queso.
Were they real firearms?
Yes.
Did he typically use fake guns in his music video like that?
No.
After the murder of Charles McCormick on January 15, 2020, did you ever see Hakeem with that black AR style rifle pistol again?
No.
Are you aware of a dash cam video that recorded the murder of Charles McCormick in this case?
Yes.
Have you seen that video?
Yes.
And the person captured.
Objection, sidebar.
All right, let me see counsel and court reporter at sidebar.
So I know they going to sidebar. Y'all know we got Seagull time on this, so I will go past this. But yeah, I agree. Like, I mean, he did all this dirt. He was an informant at one point in time. Like, how do you, like, your son got a -year-old. Like, whoa. Can you hear me now? No, I don't know. You should be able. Am I not on there? I should be. Yeah, no, they and they like the best at this, right? Yeah, I was just saying that it's amazing to me how he was an informant before, right? And I told y'all they were professional snitches. That guy Butter, the other one that was at the thing that was involved in the incident, that wasn't his first rodeo as snitching. So it really bothers me that how you get to go out here and do all these crimes and the way you get off with lesser time is to snitch on somebody and then come back out and do some more crimes. And yeah, Jason, I see where you're saying like he got a lot of nerve, like you gonna throw the older son up under the bus in order to be with the younger kids. I think that also with them, it just may have been overwhelming evidence that he knew that they had too much on his son. So I guess why not take a deal? Yeah, the 13th year, I agree. These guys are very corrupt. But I think that the system in Jacksonville also allows them to. Right? Like if you give it passes, thank goodness in the unaliving of the Julio, y'all, I want to keep calling them Julio Fulio. So if we do cover that trial, y'all gonna probably have to correct me or laugh with me or just say whatever, Sweet Pea, because I'm probably gonna be calling him Julio Fulio the entire trial. And trust me, I do know that his name is not that, but for some reason, I have named him Julio Fulio. OnlyFans says the courts value corroboration more than anything. Clearly, Film Fee says people with good morals don't understand these people. Right. Because I'm like, okay, if you get off with the first snitching job, then I'm going to call it a job because these two, they were definitely professional. Like who memorizes all them numbers? And they were not memorizing them, but I bet you they had that information and they said they're going to go up there and tell it just like it is. They memorized those numbers for this trial. Like, I don't believe for 1 minute that they just saying this stuff off the top of their head. And we talking about 5 years ago, y'all. I mean, this just goes deep. And when we even think about like what Lil Durk, if any of y'all in regards to that, like what he involved in with that big Rico case that he got coming up. He said when you get locked up, you got to remember numbers. Yeah, well, you better remember them so you can call them, right? Because you can't have your phone. And Sherry's like said, nobody remembers numbers. I'm telling you, they remember numbers from 5 years ago. I know they had to be in there with a little scratch pad, talk about this is what I'm going to talk about on the stand. It's going to go just like this. Like, even when it's times when either the defense gets it wrong or the prosecution team gets it wrong, like these certified snitches, they actually correct it. No, sir, I'm going to argue with you. No, ma'am. No, instead of it being 3 years, it was 5 years. No, I'm gonna try to show you. Let me show you the transcript where I provided this information the last time. They pulling out the transcripts for the inaccurate information. Like, no, I'm going to correct you. When most people, when they get up there, even if they have agreed to cooperate, they be like real timid, like real, scared. So yeah, like this is like crazy work to me in regards to this. Like, and it's times where I think he even like his eyes got red and stuff. Like he just feeling some kind of remorse for it. But I don't know. Neither one of them did a Woody. That's what I would tell you. Like, I don't know nothing about this. I didn't say that. I was just blaming them people because I was trying to get out of some stuff. I did these crimes. Right? They didn't do a little Woody. But let's see what Daddy had to say.
And so you would see him on a daily basis?
Yes.
And as you have testified to, he's your biological son.
Yes.
And did you also see him after January 15, 2020?
Yes.
And when he was living with you in your home, did you become familiar with some of the clothing that he owned?
Yes.
See the types of clothing that he would wear?
Yes.
See him as he...
Okay, Phil, rephrase your questions.
Did you ever see him walking about the house?
Yes.
Did you see him in music videos?
Yes.
Right. Are you familiar with the way he moves?
Yes.
Are you familiar with, or 5 years ago, were you familiar with the way his build was, his physical characteristics?
Yes.
And after January 15th, 2020, you became aware of a video recording that captured the murder of Charles McCormick. Is that correct?
Yes.
And you've had an opportunity during the pendency of your case and the discovery to see that recording.
Yes.
Correct. Okay. Did you, when you viewed that recording, recognize the person depicted in it?
Yes.
Who is the person that was captured on the video recording shooting Charles McCormick?
My son.
What's your son's name?
Hakeem.
After the murder of Charles McCormick, did you become aware of a post on Hakeem Robinson's Instagram account referencing something that happened?
Yes.
And was that posted from a nail salon?
Yes.
And after seeing that post, did you reach out to Hakeem Robinson, your son?
Yes.
And what did you want him to do?
I want him to remove the post.
Are you aware of any other posts Hakeem Robinson made to his social media around that time that concerns you?
Yes.
What was that?
It was another post of dude Lil Buck.
What did you see?
It was just the emojis on the bottom of it that said bye bye bye.
Say it again.
It was the emojis, the hand emoji saying bye bye.
States 227. That the nail salon post that you reached out to him about? And by him, I mean Hakeem Robinson.
Yes.
Showing what's in evidence as... One moment, I'm sorry, Judge, just not looking. I believe it's States 240, a composite. Do you recognize that, sir?
Yes.
Who is that in the post?
Willie.
Billy Addison?
Yes.
And whose Instagram account is that?
Hakeem.
I'm showing you states 229. Do you recognize this photograph?
Yes.
And whose marker is there that at the bottom of the photograph?
Willie.
Who's surrounding it?
Hakeem, Pooh Red, and Kareem.
It's Pooh Red again. Is that Torgon Williams there in the middle?
Yes.
State 241. Who is that?
Kareem.
Abdul Jr.?
Yes.
And stage 240, showing you what's in evidence as a photograph that was sent, appears to be from phone number 904-866-2370. That was your phone number?
Yes.
To 478-305-9583. Do you recognize the photo that was attached to that message?
Yes.
Who is that?
That's me.
And who were you sending that to?
I sent it to Hakeem and Kareem.
So you sent it to both Hakeem and Abdul Jr.?
Yes.
Is that to both 478 area code numbers that they had?
Yes.
And why were you sending that to them?
I really don't know. I really think I was just showing off my outfit, to be honest.
Now, though some people may not believe it, even though you sat here and testified here today, do you still love your family?
Objection, relevance.
Overruled.
Yes.
Is this easy for you to do?
No, it's the hardest thing I ever had to do in my life.
Judge, I don't have any further questions.
Okay. Cross-exam from Mr. Whitaker?
John, may I please the court?
Yes.
You love your family, Mr. Robinson. That's what we just heard, right?
Yes.
I guess you love yourself. Right? Yes or no, sir?
Of course. Self-love first, right?
Over your children.
That's the law of nature. Love yourself first.
Okay. You're cooperating in this case, correct, sir?
Correct.
This is not your first cooperation, is it?
No,
You've somewhat made a career out of it, have you not?
I wouldn't say career.
Well, you first testified against an officer, Officer Eric Sinclair, back in
Relevance.
Overruled.
1999, right?
Did I do what?
You testified against Officer Eric Sinclair back in 1999.
No, I didn't.
Came forward with information.
Yeah.
The officer evidently didn't take it to trial, correct?
Correct.
But your cooperation, your testifying to the federal government caused him to enter a plea, right?
I'm not going to agree with that.
Okay. Well, what you probably will agree with is that your sentence was dramatically reduced, right?
Yeah.
I mean, isn't it true that before you talked to the federal government, what you were facing back in 1999, you could have gotten up to life imprisonment, correct?
Yes.
And it was reduced to 10 years, right?
Nope.
Substantial reduction?
My time was reduced to 22 years.
How much did you serve?
About 10 years and 3 months, 4 months.
Okay. So from life to an ultimate actual serving sentence of about 10 years.
Guess what? It was a law change, and that's how my time got reduced again.
Well, and your cooperation, sir.
Yeah.
Right? So pretty good deal you made for yourself.
Yeah.
You've also worked as a confidential informant for police, haven't you?
Yep.
And you're cooperating in this particular case because it will help you, right?
Right.
And you were arrested, I think you told us roughly September of 2020.
September 10th, 2020.
September 10th, it sounds like you remember the exact day,
Yes.
right, sir? I imagine that was an important day to you, correct?
I ain't gonna say important.
Well, it did cause you to be incarcerated, sir, right?
Right.
Where you've remained, correct?
Right.
And that was for your involvement in the McCormick homicide, right?
Yes.
When did they hit you with the Rothermel homicide?
2021.
Okay, so in 2020, you're facing an accessory after the fact charge for your involvement in the death of Charles McCormick, right?
Right.
And when they brought you in, you've agreed to cooperate, right?
Right.
But that didn't happen until 2022, correct?
Right.
That would have been after they put the second homicide on you, right?
Right.
Now, in the Rothermel homicide, you're aware that Dominique Varner originally was going to testify against you, right?
Right.
And your involvement in what you pled guilty to as accessory after the fact in the Rothermel killing was that you admit you gave money to Dominique Varner after knowing he had just been involved in the shooting and needed to get out of town.
Yes.
And you're willing to admit that, correct?
Yes.
You do not admit, you do not agree with Mr. Varner's claim that you provided a gun and a car to accomplish that drive-by shooting.
Right.
Okay? You don't agree with that,
No.
right?
No.
Because based on your knowledge, sir, you understand that if you and I plan to do a crime together, whatever crime, we're both considered principals, right?
Yes.
And so you can stay at home. But if you and I agree to do a crime and I do everything, but you help me, you support me, you do something, say some word that actually inspires me, that encourages me to commit the crime, you can be punished as if you did everything I did, right?
Right.
But you weren't charged as a principal in the Rothermel killing, were you?
No.
And so you were left with solicitation for murder. I guess you were originally arrested for that charge, right?
Yes.
And essentially, you understood that that charge, they were accusing you of trying to entice the murder to happen, right?
Right.
But they dropped that charge pursuant to your plea agreement, right?
Well, I think it's going to be dropped.
I'm sorry?
I think it's going to be dropped.
Okay. You just know you haven't entered a plea to it, sir, right?
Right.
That was not part of your plea agreement for you to enter a plea of guilty to solicitation for murder, correct?
Right.
Only accessory, right?
Yes.
And accessory after the fact, you understand, and you understood before you entered your plea agreement that that's punishable by up to 30 years.
Yes. Yes.
So when you have two of them, that means that you could be sentenced up to 60 years, correct?
Correct.
But in 2022, when you agreed to come forward and cooperate, they cut your exposure by 2/3, right?
Yes.
I mean, I'm never been super great at math, but 30 plus 30 is 60, right?
Right.
And your plea agreement for the death of two human beings calls for a maximum of 20 years, right?
Right.
And your actual guidelines are only about 7 years, right?
Right.
And I think you told us that that was based on your age, your health issues, and you want to be there for your younger kids, right?
Yes.
Would you agree with me? You weren't there for your older kids.
That's why I know better this time.
Okay. You did grow up with quite a bit of respect on the streets, sir, didn't you?
Yep.
And you personally never met Charles McCormick,
Nope.
but you did know who he was, correct?
Yes.
And you knew in spring of 2019 that he had put out this rap song, correct?
Yes.
And you, as you've told us, you were physically in the car when Willie Addison was killed, correct?
Yes.
And your son, Abdul Jr., was in that car, correct, sir?
Yes.
And Torrigan Williams was in that car, correct, sir?
Yes.
And all of you got shot, correct?
Yes.
And you explained there was somebody else there that was actually also shot and paralyzed as a result, right?
Yes.
And who was that again?
My nephew,
Okay, and what's his name, sir?
Samuel Cooper.
Samuel what?
Cooper.
Cooper.
Yes.
Samuel Cooper.
Yes.
Also shot with Willie Addison, with you all, and is now paralyzed.
Yes.
And then you also mentioned somebody named Moody.
Yes.
Do you know Moody's full name?
I think it's Antonio McLaurin or something like that.
Antonio McLaurin.
Yeah, I think that's it.
Were you aware that Antonio McLaren wore a wider on Mr. Barner?
Yes. Do we need to speak sidebar about that? Okay. Let me see court reporter and counsel at sidebar.
I heard objection. I just didn't hear anything after that. When Willie Addison was killed and you all were shot, was a person with the nickname, I'm sorry, give it to us one more time.
Moody.
Moody. And you believe Moody's full formal name is Antonio McLaren.
Yes.
And my question to you was, were you aware that Antonio McLaren wore a confidential wire on Dominique Barner?
Yes.
Jail. You were?
Yes.
Okay. It's fair to say that you were vengeful after that shooting, is it not, sir?
Yes.
And that is, in fact, is why you were willing to be involved in what would become the attempted murder of someone named P. Money, and that resulted in the Rothermill killing.
Yes.
Because P. Money, and do you happen to know his formal name?
No, I don't know his full name.
Okay. But you know who I'm talking about when I say P. Money,
Yes.
correct?
Yes.
He was a target for you, correct?
Yes.
Because you did believe he was responsible for not only killing your son, Willie Addison, but hurting everybody else, correct? Including yourself.
Yes.
You were not personally there during the actual shooting of what ended up being the death of Mr. Rothermel and the attempt on P. Money, correct?
Correct.
But you have pled guilty to accessory after the fact for that death.
Yes.
And you have admitted to providing Barner with money in order to get out of town, correct?
Yes.
Now, we've heard you kind of explain that on January 15th, you end up driving your Dodge Challenger, correct?
Yes.
Over to the Townsend Road area?
Yes.
And you claim that you then picked up Dominique Barner and Leroy Whitaker, correct?
Yes.
And I apologize for skipping around a little bit, but I just realized something I almost forgot to ask you about. How long have you known Leroy Whitaker?
I've known him for probably about a little bit more than 5 years, probably now.
A little bit more than 5 years, sir?
Yeah, probably now.
Okay. And you were born in 71 or 70?
70.
1970, which makes you about 55 now, sir?
Yeah, I'll be 55 this year.
Now, back in 2020, I think you've already told us your son, Abdul Jr., was 25? That sound right?
It might be. Yeah.
Okay. Well, you told us, I mean, we can, if we have to, we can do the math.
Yeah,
Not
do
very
the
good
math.
at the math, but we can certainly do it. What year was Abdul Jr. born?
94.
Okay. So that would appear to make him 26, if my math is correct. Does that sound right?
26 now?
If you subtract what month? 2020.
November.
Okay, so we'd use 2019, so that'd make him 25 at the time of the death of Mr. McCormick.
Oh, okay, yeah.
That sound about right, sir?
Yeah.
Okay. And you said that there's a 4-year age difference between the two sons, between Abdul Jr. and Hakeem Robinson, right?
Yes.
Okay. So if depending on the birthdays, and again, we're talking November, so if there's 4 years, then Hakeem Robinson was 21 years old, right?
Yes.
When was Willie Addison born? What year was he born?
I think 93. I think. I'm not 100% sure.
1993, which would make him 26.
At 2020, right?
Okay.
Yeah.
Okay. And in 2019, when he was killed, he would have been 25.
Yeah.
Okay. Leroy Whitaker is substantially younger than all of them, correct?
Yeah.
And you always knew that from the little time that you did spend with him, correct?
Yes.
And Willie and Leroy Whitaker had no relationship whatsoever, right?
Not that I know of.
And Leroy Whitaker does not rap that you're aware of, correct?
No.
And with all of your testimony, though, you have not heard Leroy Whitaker specifically ever make any kind of statement that he wanted Charles McCormick dead, correct?
Correct.
And you have never heard Leroy Whitaker ever say anything to suggest he knew anyone was going to get out of a car and shoot Charles McCormick, correct?
Repeat that question.
You never heard Leroy Whitaker say anything that he would have any knowledge that anyone was going to get out and shoot Charles McCormick.
No, I haven't.
And sir, have you ever been convicted of a felony or a crime of dishonesty?
No. You said a crime of dishonesty?
And I'm sorry, but let me make it easier.
Yeah.
Have you ever been convicted of a felony, sir?
Yes.
How many times?
2.
Nothing further.
Okay, cross for Mr. Robinson.
Your community up until this point, seated right there, right?
Say that again?
Your community, your family, those people that know you best in this world are in this courtroom right now, right?
I don't think so.
You don't see family sitting there?
Nope.
You don't see Hakeem's mother sitting there?
Oh yeah, I see her.
Now, of course, she knows you, right?
Yeah, she know me.
A moment ago, you said that you are a 2-time convicted felon. And let's jump into the first time. In the year 2000, you were sentenced to 262 months in federal court, correct?
Yes.
Hakeem was an infant at that time, right?
Yes.
You go away for roughly 10 years.
Right.
Now, you said a moment ago that, well, that you disagreed about cooperation. You got what's called, the government filed a 5K, right?
Yes.
And a 5K specifically is when somebody has provided substantial assistance in the investigation or prosecution of others. You agree with that?
Yes.
But you disagree that you got a reduction because of cooperation?
No, I don't think I disagree with that. She said testifying.
All right. You snitched on other people, you got a reduction, right?
Yeah.
All right. So years later, this case comes along. You get charged in the McCormick case. You get charged in the Rothermill case. And you initially plead not guilty, correct?
Right.
You fight the McCormick case for a period of time, right?
Right.
You have your attorney involved in depositions knowing the facts of the case, correct?
Yes.
And then your attorney comes to you and says, they're threatening to charge you as a principal.
Objection, Judge.
And the grounds?
Privileged communications.
Okay,
For him to waive, Your Honor, not the government to say.
okay. Well, then I'll leave it to Mr. Abdul Robinson Sr.
There was a point in time when these two murder cases are pending that you learn that the government is now trying to leverage you, threatening you with charging you as a principal in the Rothermill case, right?
Yes.
And that would have meant a life minimum mandatory for you, right?
Yes.
So you agree, you cave, and astonishingly for the second time, why is it that you only grow a conscience when you're looking at hefty prison terms?
Objection, argumentative.
Sustained. Just ask a question, Mr. DeCoste, without commentary.
Previous case, you were looking at life, you cooperated to get out of it, right?
Yes.
Once again, you're looking at life and you decide to cooperate to get out of it, right?
Right.
Now, you're hoping that the recommendation is going to be that you serve for all of your crimes only 76 months, right?
I mean, yes.
All right. That's what you have in writing with the government, right?
Yes.
And you've served a majority of that time already.
Right.
So that means that within a short couple of months, maybe 12, you're going to be back walking the streets of Jacksonville.
Yeah.
That was the price of your testimony. Right?
Right.
You had to cooperate and implicate your two sons, but it got you out of custody.
You say implicate them?
You had to point at your sons. Let's back up for a second. At the point in time that they leverage you with life on the Rothermill case, they had already arrested your son and said that he was the one that committed it, right?
Oh, no, you confusing me.
Okay. Let's break it down. You said a moment ago that the government sent a message to you that they were going to basically indict you on the Rothermill case and that you were potentially looking at life. You then decided to cooperate. You remember that, right?
Right.
Okay. They had already, on this case, through the evidence, through the depositions that your attorney was at, they already believed that Hakeem was a shooter, right?
Right.
All right. So it wasn't something that you came forward and like, hey guys, let me help you understand the case. You just agreed to their narrative.
No, I didn't agree to their narrative. They asked me what the conversation was when I picked them up.
Okay, let's move on here. So at that point, though, they had already pointed the finger at Hakeem, right?
Right.
All right. So you just continued with their case. I'm going to point at Hakeem. He was a shooter, right?
I can't agree with that.
You also pointed out your other son, Abdul, the one that shares your name, Abdul Kareem Robinson Jr., right?
Right.
Now, before you decided to cooperate, you had also reviewed all of the phone records in this case, correct?
Yes.
So you had knowledge of what the government believed was happening in the case.
Yes.
Now, let's talk about Dominique Barner. Your words, he's a reliable hitman, right?
Yes.
For you to know that he's a reliable hitman, you must have used him as a hitman before, right?
No.
And how do you know he's a reliable hitman? Can't be the Rothermill case because they didn't kill P Money. So how is it that you know that he is a reliable hitman?
I mean, you hear things when you're in the streets.
And that's where you live. Not physically on the streets, but you are a street guy, right?
I have been one.
All right. And the marks of that are on you. You have bullet holes, right?
Yes.
You have tattoos, right?
Yes.
Keem has neither.
Right.
Not a single tattoo on his body, right?
Right.
Never been shot.
That's good.
Now, let's get back to Barner, your reliable hitman. In the Rothermill case, it's Blue. That's you, right?
Yes.
Now, you also go by OG too, right?
Yeah.
Okay. So it's Blue, Butter, right? Dominique Barner.
Yeah.
And Chris Brown, right?
Yes.
That's the trio. Blue, Butter, Brown. In the Rothermill case, right? Right?
Yeah.
Now, Chris Brown, his nickname is Crazy Chris.
Right.
You know Chris Brown, obviously.
Yes.
State. All right. Your Honor, may I approach?
Yes.
All right, Mr. Robinson. I'm showing you it's been pre-marked. It's defense one. You know what that is, right?
Yes.
That's a picture of Chris Brown.
Right.
And you know that's a picture of Chris Brown because you committed crimes with him.
No.
You're denying that you committed crimes with him on the Rothermill case?
Yes, I'm denying.
Okay, just a moment. When there's an objection, I have to rule. What's the objection?
I withdraw based on the way it was been phrased.
Okay. Go ahead, ask the question.
Chris Brown is a co-defendant on the Rothermill case, right?
Right.
And you pled guilty on that case?
Yes.
Now, this photo fairly and accurately depicts what Chris Brown looked like in January of 2020.
Yes.
Defense offers with pre-marked as defense one.
Okay, so any objection from the state? Any objection from Mr. Whitaker? Okay, then defense exhibit will be marked into evidence as defendant Robinson's number one.
That's Chris Brown, right? Can you see the monitor?
His monitor is not on.
Published all. Mike taught me better.
Well, it's off everywhere now.
There we go. Now, there we go. It takes a minute.
Okay.
That's Chris Brown, right?
Yes.
Butter pecan skin. Right?
Yes.
Not Hakeem.
No.
Dreads down to his chin, right?
No.
He's got dreads, no?
Yes.
Some of that hair goes down to his chin.
Talking about hair on his chin?
Down to his chin.
Yeah, he got hair on his chin.
All right. Now, Chris Brown's right around 6 feet, maybe a little bit under.
He
Right?
might, yeah, he might be about 6 feet, a little bit on.
He's a skinny guy too, right?
Yes.
He's also best friends with Butter.
Yes.
Crazy Chris, Chris Brown, and Butter Dominique Barner. Right?
Right.
Now, Dominique Barner, he lives that life too, right? He's got wounds, he's got tattoos.
Yes.
He doesn't have a future in the entertainment industry.
No.
None of them do.
No.
Now, let's talk about work. been out of custody since, roughly 2009, July 2009, you get out of custody on that federal case?
Yes.
In your life, you have never filed taxes, right?
No.
Judge relevance.
Yes, sustained.
Never received a paycheck from a legitimate job.
Yes.
Now, the House of Pain, your Instagram handle is HOP CEO, right?
Right.
That stands for House of Pain CEO.
Yes.
That's yours from back in the 90s, right?
Right.
When House of Pain, that's my era, when House of Pain was big. Right?
Right.
That's not Hakeem's era.
No.
Now, you had shirts that were put together, right?
Yes.
You even have like drawings where you tried to draw out the crest for House of Pain.
Yes.
And you were hoping to build that into something legitimate, right?
Yeah. Yes.
Legitimate. The emblem, correct me if I'm wrong, is an axe on the right side, right?
What?
Do you remember the logo that you drew?
No.
To refresh your recollection, to take a look at what you drew?
Yeah.
Brief moment, Your Honor. Take a look at that. You know if that refreshes your recollection.
Oh, yeah, yeah, yeah.
All right, so the House of Pain logo that you created, it's got a house with bullet holes in it, right?
Yeah.
Below that, stacks of money, right?
Right.
A microphone.
Under relevance.
Yeah, how is this relevant?
Your Honor, do you want me to go sidebar and explain?
No, I'm going to sustain.
Okay. A House of Pain email that the government has talked so much about today, that's also yours, right?
No.
So House of Pain and everything about it is yours except the email address.
Yeah, I can't remember making no email address for House of Pain.
When the police searched your house in the U-Haul truck that was out there, they found T-shirts for House of Pain. They found other swag that you had made and these drawings for House of Pain, right?
I don't know. I wasn't there.
And again, your Instagram handle is HOP CEO.
Yes.
All right. Now, let's talk about Hakeem Robinson. Hakeem is 6'2", 6'3", your words?
Yes.
Well over 200 pounds?
Yeah.
230, 240?
About 230.
In 2019, an opportunity came his way, right?
Yeah.
He was close friends with another rapper by the name of Young and Ace, right?
Correct.
He's known Ace for a long time.
Correct.
Ace has gotten hugely big over the years, right?
Correct.
Now, at the time, Ace was signed by Cinematic, right?
Correct.
And at that time, Hakeem was lucky enough to get connected with Johnny Shipes, right?
Correct.
Now, this is the same guy that found Nipsey Hussle in California, right?
Correct.
Joey Badass, right?
Yeah.
T-Pain.
Yep.
So this wasn't a small deal. This wasn't Charles McCormick's song that's out there. He had a legitimate record deal.
Right.
Now, we know from Charles McCormick that people in this diss rap and this drill rap, they will rap about things that they weren't involved in, right?
Correct.
Because you said Charles McCormick was not involved in this.
Correct.
Now, you also agree that drill rap, the type rap like the video, Bang It Out, that sells, right?
Yes.
And I asked you, and I think I asked you, and it was a couple years back, sells a lot better than happy rap, like Will Smith rap.
Right.
Right?
Yeah.
Now, you had hopes prior to manage Ace, right?
Yes.
But he didn't take you along.
No, he already had a manager.
And then your son gets signed in 2019, right?
Right.
He's off in California shooting a music video in December, right?
I can't remember.
He didn't bring you along either.
That ain't true, man. That's not true.
He did not agree to let you manage his career. Or is your testimony that he did? He wanted you to manage it.
Of course.
Of course not. He didn't want you to manage it.
Of course, he did.
Yet you weren't with him on any of those trips, right?
I was with him on a lot of trips.
You have no credits on any of his songs?
No, I don't want no credits on this song.
And Johnny Shipes is the one that is in the records as his manager. Right?
I would assume.
So let's now talk about the day before the murder. That white car that you already let us know, you drove that white car over to the JSO property facility, right?
Yes.
You remember that?
Yes.
Now let's talk about the motive of others. Your testimony is that Hakeem Robinson, who was not shot, who is not biologically tied to Willie Addison like you, that somehow he had more motive than the other people that were actually shot. Right?
Say that again.
We're talking about the people that would have had a motive to be upset at Charles McCormick. Okay?
Right.
You, Butter, and Brown, Blue, Butter, Brown. I'm going to trip over that if I say it fast. The whole thing about P Money was because you believe that he was behind Willie's murder, right?
Right.
Okay. So now Charles McCormick comes along and he's putting out a song. He's not signed to a record deal, right?
Right.
His song isn't getting any traction.
Right.
He's nowhere near the level of Queso, Hakeem Robinson, right?
Correct.
But your testimony is that was a motive enough for murder. That's your testimony, right?
It's this song?
Yes.
Yeah.
Okay. But there's a whole list of people that would be way above him to have the motive to kill Charles McCormick, right?
Right.
You?
No.
No?
No.
You'd have no motive to kill a guy who's basically laughing about the night that you were shot.
I mean, not me. Shouldn't kill him pro se myself?
Look, all I know is this. I'll put this in a question. You claim that the phone that's used by the shooter, that's registered in your name, right? Oh, excuse me, Darrell Watts. Right?
Right.
And we'll get to that. You allegedly burn the clothes that Butter had on him, right?
Correct.
You break through the police perimeter to pick up Leroy Whitaker and Barner, right?
Come on, man. You exaggerating, man. You know it wasn't no police perimeter, none of that. You exaggerating now.
I'm exaggerating that there wasn't drones and helicopters overhead.
How would I know that?
Because you were driving to the location?
And I would see a drone in the air?
So we'll agree. All right, let's say the JSO. We'll let JSO answer the question whether they had a perimeter and they had hundreds of officers trying to find the shooter that was running through neighborhoods.
You really think I would have went through there if I seen all those police and all that? Or a drone and a helicopter and all that? You think I would have went up in there with my car registered in my name?
You don't want me to answer that question. So why don't you stick to answering my questions and not asking me them? It's a life you live, right? You live this life in the streets, right?
Nah.
Or wait, are you telling me that you as the patriarch of the family, that basically these kids come by and say, hey, Blue, go do this.
They didn't call Leroy Whitaker daddy to go get it. They called me. They did. What if they would have called some? I would like to see how they would feel if they would have called somebody else to go pick somebody up. They didn't. They called me. If I would have knew something was going on, I wouldn't have never went.
All right.
Think I'm gonna go over there in my car with my phone and knowing something going on? I would like to been, if I would like to been involved in a crime, I'd like to know that I'm involved in a crime. Let me know that, okay, it's a crime happening now. Let me know something. I was in the blind.
So you're a victim in this case, right?
I ain't gonna say I'm a victim, but I would like to know that I'm being involved in something and just ask for a ride.
All right. So then after you know about it, you're then cool with going to burn clothes, right?
Yeah, after I get to know about it, I was cool with that.
Yeah. What's a little bit of a felony? You know, destruction of evidence.
Yeah, I did it. I like Scotty. I did.
Definitely know you didn't call 911.
Right.
That conscience only grew later when you were looking at life.
Yeah.
All right. Now let's talk about Darrell Watts. There's a bunch of cell phones that are in the name of Darrell Watts, right?
Correct.
And the phone that was used. Now, it's interesting. The government, they asked you about a bunch of phone numbers and you remembered it off the top of your head, right?
Yeah.
But the one that they had to tell you was 478-305-9583.
Objection, Judge.
What's the grounds?
The misstatement.
Okay, I will, of course, the jury will recall the testimony that came out from the witness stand, if you'll just ask the question of the witness.
You were asked about a bunch of phone numbers and you were able to recite them except for one that they told you and you just agreed, yes. You remember that, right?
Yeah, I remember that.
And that's 478-305-9583, right?
Right.
Now that phone's under your dead friend's name, Darrell Watts, right?
Right.
You paid for that phone, right?
Correct.
And in December, you paid something like $1,000 that you owed on that phone and others.
Right.
So whoever it is that had that phone, the shooter, you supplied it to him.
Oh, I didn't know the shooter had the phone. I didn't know. I mean.
So, Darrell Watts was your best friend, right?
Yeah.
He was murdered.
Yeah.
To this day, you are not cleared as a suspect in that case.
Sustained. Mr. DeCoste, just ask questions, please, that are relevant.
An arrest has not been made in the murder of Darrell Watts.
Objection, Judge.
Sustained.
Now, you've also learned that Torgon Williams was involved in the murder of Charles McCormick, right?
He was involved?
Yeah.
Oh, no.
You don't know that?
No.
You were a co-defendant for a while. Your attorney's going to depositions. You don't know the other people that were implicated?
No.
Chris Brown?
In Charles' case?
Yes.
No, I never seen that. No, I don't know that.
Janera Smith?
No.
But none of them have been charged.
Right.
Now let's focus on the specific day of January 15th, 2020. Your words, you didn't see Hakeem that entire day.
Correct.
Didn't see him before, right?
Right.
Didn't see him after.
Correct.
Now you said that you were worried about him, right?
Correct.
Well, you have all these phone numbers that you have memorized. You didn't call any of them.
Correct.
But you were concerned?
Yes.
Common sense dictates that if you're concerned about your son and that what you're saying is actually true, that you would have picked up the phone and called him. But you didn't do that.
Correct. I didn't.
Chifton Hogan. First time we've ever heard it's somebody you're related to.
I'm not related to him.
Okay, but it's somebody that's a couple degrees of separation that's tied to the family, right?
He's my baby, mother, brother.
And you know from this case that he was never charged, right?
Correct.
Yet his DNA is inside of the car. Right?
Oh, I guess.
I'm not asking you to guess. I'm saying, do you know about the evidence in the case to which you pled to?
Some of it.
All right. Are you aware that Chifton Hogan's DNA is found inside of the car?
Yeah.
So you are sure now?
Yeah.
That would stand for the proposition that DNA can end up inside of a car without somebody ever being in it, right?
I'm not sure.
All right. So your other son, Abdul Jr., he's not here anymore, right?
Correct.
Your hope, something that has been discussed, you're hoping that in exchange for your testimony here today, that his case would be dropped. Right?
No.
You're not hoping for that?
I mean, if it do, it's good. I mean, but I can't say that.
So you're saying that that's not true, or you're saying it's not, or you're saying you do want your other son to be convicted?
No, I'm not saying I want him to be convicted. I'm not saying that I want him to be convicted. If they drop his case because of what I'm doing, great.
As long as you're protected, that's the most important thing for you, though.
When you say protected, what you mean?
The same thing that Ms. Schlax asked you. You said, well, if they drop his, well, that would be great. But your number one priority out of all of this is you.
I think I'm number 2.
Sir, you come in here as a 2-time convicted felon. Because of these other cases, you'll be convicted at least 2 more times, right?
Right. Correct.
A lifetime of crime, right?
Objection, Judge.
Sustained.
You'll be a 4-time convicted felon. You've already spent 10 years in prison and approximately 5 in custody on this.
Correct.
For a total of about 15 years in custody.
Correct. Let's not forget about the 10 years that I was out free and no trouble.
But then you got into trouble again.
Right. I was out free from 2009 to 2020, no trouble.
I understand, but coming in here today and going back to the question, your number one objective is protecting yourself.
Of course.
One brief moment, Your Honor.
Okay.
Mr. Robinson, one more thing. The deal with Cinematic, that occurred right in the months before this murder, right?
Yes.
Basically, right around December, they fly him out to California. He's shooting music videos, but it's right around that time that he inked that deal.
I'm not sure. I don't remember him going out to California, so I can't say.
But you can say that that deal was inked right around that time.
Yes.
Nothing further, Your Honor. Thank you.
All right, thank you. Is there any redirect?
A little bit, Judge.
Yeah, police court.
Yes.
Mr. Robinson.
Yeah.
That 478-305-9583 number that you were asked about, that was under Darrell Watt's name.
Yes.
Did you give that number to Chris Brown?
No.
You didn't let him use it?
No.
Sure.
Positive.
Now, on going to show you what's in evidence. It states 187. Is that on your screen?
Yeah.
Objection outside of the scope of cross.
I don't have a question.
Judge, I'm going to ask about this Brown.
Okay, then that's permissible. So objection overruled.
Is that Chris Brown? That was shooting?
No.
What?
It's Hakeem.
And you indicated a few moments ago that Hakeem's approximately 6'2". Have you ever measured him, or are you just going off what you believe?
I never measured.
As he sits here today, does Hakeem Robinson look the same as he did 5 years ago?
No.
Overruled.
What's that?
Does he look different today, Hakeem Robinson, than he did 5 years ago? Has his build changed in any way?
Yeah, a little bit. I mean, he look a little grown, like, you know.
So he was smaller 5 years ago?
Objection, leaving to strike.
Okay, sustained. Just rephrase your question.
You said bigger today?
Yes.
Objection, leaving to strike.
Okay. There's no evidence to strike, so I'm not striking. It's because the attorney's questions are not evidence. Anybody's attorney's questions are not evidence, but rephrase your question without leading.
Judge, sorry, Mr. Robinson, I didn't hear your answer. When I asked you, how does he look different today? What was your response?
He look like he grown, gained a little weight.
Now, you were asked a lot of questions about the deal that Hakeem Robinson signed with Cinematic. You remember that?
Yes.
And some questions about him going to California to film a music video.
Yes.
But the Bang It Out video was filmed right here in Jacksonville, right?
Yes.
You were there for that?
Yes.
Now, are you familiar with Robinson Management, LLC?
Who?
Robinson Management, LLC. Does that sound familiar to you?
No.
Were you involved with Hakeem Robinson's cinematic endeavors to be signed?
Yes.
And were you trying to assist him with that and manage him with that?
Yes.
Did you?
Yes.
Were you in fact in communication with people from Cinematic?
Yes.
And were you continuing to aid and assist Hakeem with that?
Yes.
May I approach the witness, Judge?
Yes.
Objection, Your Honor.
I'll try. May I approach, Judge?
Yes.
When you a document, take a look at it yourself. I'll let you recognize it. part of that agreement with cinematic music, were you actually on that contract?
Yes.
How so?
I was his management.
Okay. And you signed that form?
Yes.
Did Hakeem Robinson sign it?
Yes.
One moment, Judge.
All right.
That's all, Judge. Thank you.
All right, may this witness be excused?
Request for recross, Your Honor.
Okay, but it's very limited to redirect.
Mr. Robinson, you were shown that video, right?
Yes.
The government asked you who that was, right?
Yes.
If you said anybody other than Hakeem, you'd still be looking at life, right?
Yes.
Nothing further.
All right, may this witness be excused?
Yes, Judge.
All right, thank you.
Yes, Judge.
All right.
You know, I was thinking of something. I said, you know, you can tell that like they are professional snitchers, testifiers, whatever you want to call it. Like they are so professional. Like typically, like if somebody comes in there, and even a person that's probably like really being honest with what's going on, and just may have some details mixed up. Typically, when snitches come in there and tell on something, they start to retract, or you know, it's a story that is made up or fabricated in some type of way, and either the prosecution team or sometimes the defense team, they'll pull out the interrogation video, right? Or the transcript, like, well, this is what you said on such and such a date. Like these professional snitches, they do know it all. They were in they definitely were in these situations, right? And they must have been all telling, I mean, they were telling the truth at the end of the day, right? Like, wow. Typically they'll be like, or start retracting some stuff or something to that effect. And no, not with these ones. Like, we don't even have to go to the transcript to find a number. We don't have to go to the transcript to say what you said on this day. So I guess that really probably made them very credible, because they do have interrogation videos for him and the other guy, Butter, or whatever his name is. And Dad's testimony definitely matches the interrogation. Like, it definitely matches. Like, there's no if, and, or buts. It's so crazy because the police officer that they had on the stand that we listened to for this trial, they brought out his statement on him. Like, you said this when I took your deposition, or whatever the case may be, whatever it was that they were confronting him on. So that lets you know, like, they got this down to a T. Like, we gonna get out. We gonna make sure everything goes smoothly. You ain't got to pull that. You ain't got to pull that deposition out. You ain't gonna have to pull out no transcripts. I am the transcript. I am the video. It's the same thing. I was just thinking up here, like, that is amazing work. Right? That's amazing. Whew. Something else. I'm blowing stuff off the doggone thing off my keyboard that I got stuff everywhere. Ooh. So I don't know. Do y'all want to do something else? Y'all want to watch more of this trial? We didn't finish this trial up. I don't know. What day was this? I don't even know what day this was on.
Could you please state your name for the record, sir?
Abdul Robinson, Sr.
Please stay close to them.
Met day 3 or 4. Darn, they had a lot of bees. You got blue, little bug, butter. All these people with all these bee names. Oh yeah, that was day 4. It was a 7-day trial. You say time stops, right? You start remembering everything. Yeah, them snitches, boy. I don't even know if they had anything on. I was trying to see what they had on day 5. I'm a B. I'm a B. Okay, that's great to know. She's a B. Oh, she must be talking about my butters, my bees, all the bees. Y'all know I'm slow. Let's see here. Mm. That's not nice. Look, that's not nice. Let me see. I don't know. They kind of threw me for a loop without this this trial that we were supposed to cover today. I'm like so irritated with that fact. I just knew I was gonna be I just knew we was gonna be I was really deeply interested in this trial. Now I guess now I gotta look at notes and stuff and whatever they come up with. So I think that maybe we'll call it maybe an early Friday, right? He said I was just affirming a statement. Okay. Yeah, so I think what we'll do is because I don't have nothing to do besides look at this, and I mean I could look at it, but ain't that we can't get to it. Right? Yes, Jules. I think we're gonna call it an early Friday. Everybody can get their plans, and we'll plan to be back here Monday. I'll send out the notification alert. That way we can start our new trial on Monday. Hopefully the feed will be correct and right. And if I see anything that piques our interest or be informative to us over the weekend, I'll definitely let you guys know because I am going to. Yeah, I am. I am. I don't think you even know. I'm like really salty about that. I knew it was good. It was gonna be some mess with that old trial. But I don't understand. I don't understand why. And then when you go to Court TV's website, they still got that old drop down. Like, really? No. She did the mom? No, I probably because I was mad at Court TV. I'm going on there now. Let me see. I know I see the victim, Erica Torres, in our last case, the one that was shot 5 times is on there. No, I don't see that. Let me see if I can search it on YouTube. Hold on, I found. I'm gonna look and see if I can see it. I wouldn't mind seeing. I mean, did she speak English? The attorneys didn't speak on that one, did they? Yeah, it's definitely one of those days. Therapist is definitely the first of the month. Bone Thugs, right? Yeah, I don't see that. Yeah, I want this. I want the jurors to really, 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 really do an interview. Like if Karen Reed's jurors did an interview, and the people from the Preppy Boy trial did an interview. Why can't they do an interview? They're going to do an interview, guys. Hey, Amanda. Let me see. Maybe I did find it, but no, maybe let me see. Yeah, I don't know. I hope they didn't take it down. But I surely don't see it. This man here. She's Turtle Boy. Okay. Well, guys, I couldn't find the interview. If I find it, we can look at it next week or so. But so we will plan to be back here Monday. The next case, I believe, is coming out of Georgia. So for anybody that's on the East Coast, it's probably 8-9 o'clock start time for you guys. And anybody that's on the West Coast, we talk about 6 start time, 6 or 7. I will send out the alert so everybody will have it. I want everybody to have a great weekend. I just kind of threw this together impromptu only because I was really, really, really weary about that case that we were covering yesterday. And thank goodness I did put this out there, and we went into the wrong chat and everything this morning because they didn't stream not a bit of that dang on case. And I'm not about to piecemeal that crap together. They gonna get that together. Like, there ain't no way to stream no case. So shout out to them for that mess. But we will be back in the courtroom Monday. Got a new trial that's starting, coming out of Georgia. Unfortunately, the body was dismembered, allegedly, by the husband and scattered throughout. So we'll see what he got, what they got going on with that, right? Amanda. Yeah, it was a difficult verdict. Welcome. Yeah, it was a difficult verdict. Yeah. Yeah, and it's just that YouTube kind of like for our M's, our M words and our K words, they are very, very, very funny about that. So just be careful. What is the case? The case is going to be, let me get it for you, Pinky. Here, I'll play the video. They got a trailer up here now. Here, I'm gonna share my screen. I'll play the video of it real quick before we get off. I'm about to show it to you, Pinky, so you can see it. I don't know. That photo looked creepy of her, but I don't know.
Local hunting club. This on the torso of a nude headless woman deep in the woods of a local hunting club. This was months before the victim, Mindy Casotis, was identified by her husband, Nicholas Casotis. And he is the one that's facing multiple charges, including malice murder for the dismembered wife murder trial. That's what we're calling it.
All right, Court TV legal correspondent Kelly Craft joining us live in studio with all the details that's happening there in South Georgia, this murder mystery. Kelly, get us caught up on this one.
Well, hi there, Matt and Julia. So this case, it begins in Liberty County. So this is about an hour south of Savannah, Georgia. Now, hunters who were looking for a deer that had run off after being shot discovered the remains of a headless woman. Her legs also were missing. As deputies searched the property, they found the victim's remains scattered within a 3 to 4 mile radius across 3 counties. The injuries were described as sharp force injuries to the head and abdomen, likely inflicted by a knife.
Kelly, really shocking details, especially in light of what we're watching right now with the Sade Robinson and the sentencing of Maxwell Anderson. But tell us how the investigators actually figured out who this victim was if you had only the torso that was located.
So the Georgia Bureau of Investigations created 2 composite sketches of the woman that was found in the woods, and then they described her as being an unidentified white female that they believed had been left there sometime in mid-November 2022. The victim had no scars, marks, or tattoos, but she did have a single tooth implant, maybe a crown, and that was located in her upper right jaw. They also found some clothing nearby, and at some point, police did get a DNA sample from Mindy's family, and that provided the match and positive identification. So investigators then announced on May 11th that the unidentified female was Mindy Casotis, and her husband, Nicholas, was arrested the next day. This was in Lancaster, Pennsylvania. At this point, we don't know why he was there, but he was extradited back to Georgia. He was granted a $5 million bond that he has not been able to raise. So he has been in custody since his arrest.
Wow, horrific details on this one. Kelly, thank you so much. I know you're going to be staying on top of it for us. What do we know about Mindy and Nick, their relationship? What can you share?
You know, Matt, that's a good question, because when we cover these cases, we like to delve into the background and try to figure out the whole family dynamic. So what we know about Mindy is that she was 40 years old. She was Nicholas's second wife. And according to their wedding announcement, they married in 2016 and they got married in Leesburg, Virginia. She was a writer, also a businesswoman, and they were living in Savannah when she was killed. Nicholas Casotis' attorney with the judge, Nicholas Casotis was an attorney. So this man was an attorney. He was a JAG attorney, so for the Navy, so the Judge Advocate General Corps. He also wrote under the pen name Nicholas Killian James Stark. And prosecutors say that Casotis owed his first wife, Heather Thomas, a $1.5 million judgment after their divorce. And they want Thomas to testify for the state as part of their case against him. His defense attorney was in court last week arguing against that. But according to local station WJCL, it sounds like the judge is considering allowing her to testify. So her testimony will be quite compelling, I'm sure. And prosecutors are also trying to introduce evidence of Casotis remarrying just weeks after Mindy was killed, and of buying some items for personal protection when you're engaging in activities. And also he bought some Old Spice at Target. Jury selection is set to begin on Monday in the dismembered wife murder trial.
So I figured they could probably explain it better than what I could say it. I did explain it earlier, what I had gathered on it. So we'll start that Monday unless I see something else that's more interesting. If you find something that's more interesting, because of course I don't see them all. Thank goodness to Moki for finding that one for us. That was very interesting. That was great. So yeah, if you see anything that's interesting, definitely email me at Take It to Trial, 2 L's at the end, and I will definitely look at it to see if it's something that we could do. If not, this is what we do have scheduled for Monday, to take a look into that to see what this case is all about. I just don't, the whole creepiness, even with that that case that the guy just got, Maxwell Anderson, that got sentenced today. I don't understand this I want to cut up the whole body like that whoa. But I don't know. I mean, that got to be a different type of sick. I mean, like a way different type of sick that I can't yeah. So we'll see how that one goes. Therapist, we was just looking at the court TV snippet of the upcoming trial that we're going to start covering on Monday. So I'll send out the alert for that unless I see something else or somebody emails me something that looks a little bit more, something different. But other than that, we'll tackle that one and see if there's anything else that comes through the week. And if not, y'all know we always got our DB. Or even if you think it's some trials that we should rewatch and replay, I love replays. So any replay trials, let me know. Maybe we'll put a vote out there. We'll put a vote, where everybody, members can vote in regards to a rerun trial. I know we were doing the DB one. We can go back in that one and do that one just so we can have fun with him. Yeah, that'll be far from now. Yeah, I seen that, the Jewels. They kind of broke the news yesterday with catching him. And he in there with no bail. Okay, you say wait. Is that enough? What's the name? What's that one, therapist? Natalie Cochran. Let me see if I can remember that one. Natalie. God, what did she do? Is this the Ponzi scheme? Yeah. Yes. Oh gosh. You said, oh, that's Mama Ali? Well, wait a minute. I couldn't find it. Let me see. Okay. Can you say her third? Oh, that one was a good one. You right. That was a good one. The Ponzi scheme. She did gave this man that medication for diabetes. That lady. Like, really? Okay, so I'm gonna be real honest in regards to this, right? I don't know how to copy and paste nothing out of this chat. Thinks about Ferris, Melody Ferris. Oh, she said, okay, bye, I gotta run. She's so cute. She'd have put like 10 messages in the thing and said, okay, bye, gotta run. Let me see. It don't, I guess because of the way I'm in there, I can't get nothing out of here. Let me see. Okay, I think I got it. Okay, I'm gonna go ahead and I'm gonna share my screen if anybody wants to hear what the mom has to say. Thank you so much for getting that for me because I could not find it. Let's see what she got to say. This should be interesting. She got a message for the daughter. Oh, she probably gonna make some people hot.
Now, for what's tipping the scales, the attempted honor killing trial ended with an acquittal on the top counts for Ihsan and Zara Ali. They were accused of trying to kill their teenage daughter, Fatima, who was 17 years old at the time. The jury found them guilty of some lesser charges for dad, most notably second-degree assault. He's only looking at a maximum of 12 months in prison, though he's already done 8. Mom was released from jail last night, and she ran right into the arms of her oldest daughter. She also spoke to Court TV. Take a listen.
If you could say anything to your daughter Fatima, what would you say to her right now?
I hope she come back in the home. I hope that. I love her. Really, I love her. I need she come back in home. Sooner sooner. I need to come back.
Yeah. Have you spoken to your husband, Ihsan?
My husband also.
How's he feeling?
I pray for him. Maybe he get out sooner.
Yeah.
He get out sooner.
So what's next for you?
Me?
Yeah.
Me? Really, my family is easy, you know. My husband, he go job. I'm take care of my kids. I don't have anything. I stay like in US. I come in like 30 years. I don't have anything trouble.
Mm-hmm.
I do everything, all what they need. But I don't know. My daughter, she like, teenager.
Yeah. What's the first thing you're gonna do when you get home?
I'll go eat my food. One tea. I miss my food.
Mm-hmm.
And my kids.
Yeah. Do you plan to call your sister?
Yes, my sister.
Yeah.
My husband.
Yeah.
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 Thank you.
Thank you.
What do you think of her reaction to her release and the idea that her daughter can come back home and everything will be fine? Let me bring back in retired FBI special.
Yikes. I do it. I said when they asked her what she was gonna do, she yelled, I'm gonna eat. I'm gonna eat. That's what I'm gonna do. I don't know what y'all came here to do, but this is what I'm about to do. And get me some tea. I bet you she can't wait till her husband get released so they can get out of here. I said they can't probably wait so they can get out of here. I don't know. Like, I don't know. She hopes she'll come back home, but it didn't sound like she is something that she about to force her to come back home or anything like that. She say she love her. I don't know. I don't know. Yeah, I just don't know in that regards. But her older daughter, I mean, I don't know. Because they said that was the first person to greet her was one of her daughters. And I mean, they do have a total of 5 other kids besides Fatima. I guess she may have been the one that was just the black sheep, as they sometimes call them, of the family. I was like, I ain't doing all of that, which didn't work well, but yeah, she mentioned the kids, Amanda. She just mentioned them after that food, I think. Yeah, you said it was just the small things that count, therapist. You said just shampoo. Yeah, well, I definitely think that I don't I just so the dad probably gonna be right out too, y'all. I didn't know that he only got like up to 12 months. So he didn't basically did his time too. That's crazy. You know, they had her on a $500,000 bond. She couldn't get out. Yeah, I'm sure they didn't have the money to get that out. You know, but what I do find strange is she speaks good English to me. Now, her, Arabic or whatever their language is, because I'm not sure. So let me put that disclaimer. Whatever language they actually speak, like she seemed like she speak English to me and understood English. So it's so funny how they was trying to downplay that during the trial. You said sweet and low. Oh, you say she learned in jail? I don't know, but she's speaking it now. She talking that talk. Gosh. Y'all think that you think that she was there at the Mesopotamian Arabic? Okay. Hey, Barbara. Yeah. Yeah, there is still a protection order. That's what she said, Paula. Did I miss that in regards to her referring to her as a silly teenager? Because I could have missed it. Oh, the mom did? Let me see. I don't know. She definitely looked happy. That's the most expression that I've seen on her face this entire time. She don't even look like the same lady. Wait, I'm gonna show y'all. Wait a minute. I do we wait a minute. She don't even look the same. Y'all sure this the mama? Look at that. Why she look so different? Or is it just me? It may just be me. I can be weird like that. I don't know. Maybe it's the color of her hair wrap or something. Not the potato head. I'm done.
Yeah.
Thank you.
Thank you. Anything to your daughter Fatima, what would you say to her right now?
I hope she come back in the home. I hope that. I love her. Really, I love her. I need she come back in home. Sooner sooner. I need to come back.
Yeah. Have you spoken to your husband, Isan?
My husband also.
How's he feeling?
I pray for him. Maybe he get out sooner.
Yeah.
He get out sooner.
So what's next for you?
Me?
Yeah.
Me? Really, my family is easy, you know. My husband he go job. I'm take care of my kids. I don't have anything. I stay like in the US. I come in like 30 years. I don't have anything trouble. I do everything all what they need. But I don't know. My daughter she like teenager.
Yeah. What's the first thing you're gonna do when you get home?
I'll go eat my food. One tea. I miss my food. And my kids.
Yeah. Do you plan to call your sister?
Yes, my sister.
Yeah.
My husband.
Yeah.
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 Thank you.
Thank you.
What do you think of
Hey, Irish. Yeah, only she looked funny without no sound. Hey, Barbara, how you doing? Yeah, maybe so. I can hear her, so it didn't help. Yeah, it did help me. I was like, I heard it. That's how I follow. Yeah, I must have missed that. Oh, boy, just come back home so we can finish it. Come on back home so we can finish this off. You get an appointment scheduled for you, therapist. You said crap. Yes, Iris, she gotta eat first. She needs some nutrition. She need to have her a good cup of tea, and then she'll work on them kids. Hey, Tanya. No, you're fine. You're fine. You're fine. Yeah, we just happened to find that our good guy friend film found it, and I couldn't find it. He told us about it, and then therapist threw it in the chat for us, right? And yeah, so we were able to find it and watch it. So she gangster now. She better than Clink. I'm done with y'all in regards to this lady. Y'all let that lady live her life. She gonna probably move back down here to Jews. She'll be back in Arizona. You know that's where they from. And they was down here before. They moved over to Washington. Well, guys, so we got our schedule, our plan for Monday. We seen the coverage that we're going to be doing for Monday. If anything else comes out, y'all let me know. I don't know. I don't know about that. I don't know, Barbara, but I'm gonna definitely be looking on here to see if they get anything. If they do get it, a juror to speak, Court TV or somebody like that, I'm gonna break the news. That's what I'm gonna do. Yeah, we know. But I'm hoping that they do speak. If they do, I'm gonna be searching online to see Yeah, I didn't see this video. I probably wouldn't have caught it because I was probably doing something where I couldn't see it. But over the weekend, I can definitely look and see. I think I think one of them will talk. And all the rest of them talk. What happened to the mailman? Irish? I don't know what they doing with Court TV. That's the same question I want to know. I need to get me a plug up in there so I can find out what's going on. What's the deal? Like, don't be teasing me with trials. Don't give me pieces and parts here. Like, if y'all the only court, live stream in the courtroom, can we get the whole feed? Can we get gavel to gavel coverage? That's what y'all told me. Y'all give me 2.5 days in pieces and parts. So yeah, I don't know if they gonna put it back up there or what they gonna do. Oh boy. I went back to my page and I could see this old Natalie Cochran, this old cray cray. I ain't gonna even call her cray cray. She just, I don't know what she was thinking. Yeah, I don't know what she was thinking. I know, right? Don't be playing with us. I don't know what Court TV was thinking. And so this morning, I thought we was going to be doing that, but I made a backup plan just because I know we were all supposed to get together on Friday, right? And I knew a lot of people were emotionally charged from the verdict. So I figured I would just open it up and, so earlier we did do a panel. And that was fun. A couple people came up to discuss what they felt about it, which was cool because, I with me talking all the time. So we watched this video. We got our schedule for Monday, and we're gonna head out. We're gonna have an early Friday, and we'll be back in court on Monday. Yeah, absolutely. I think we all agree with that. Yeah, some therapy. She gonna definitely need some therapy. And make sure she don't go back over there with that mama and that daddy. Well, all right, guys. I am going to let you guys go. Yes, everybody have a great weekend. If I find out anything, y'all know I'll send out an alert or in some type of way get to y'all. If I have to misspell the words and just get, I don't know how to send nothing fast to nobody. So if I have to send out an alert, I'll just go live. Breaking news. All right. Like breaking news. Okay, everybody come over here. All right, guys. You were in the right place today where there is no filters, no fluff, just facts. So you can be the judge. Come on, Pretty Brown. I see you. Get it, girl. Get it. She ain't been in the chat all day, but she know what that means. She know it's time to chat there. Thank you, guys. Thank you for tuning in. Thank you for hanging out with me. I would not have been able to be without y'all for 3 days. That's the crazy part. I'm like, I got to go in here. We got to do something. And have a back. Like, I can't be without them for 3 days. I know that's what I said, Jules. Like, she been in the chat. They working her. She ain't been in the chat at all today. And so now she want to come up in the chat. But she know that's with the time. She know what time it is. She definitely know what time it is. Yes, everyone. Have a great weekend. I'll let y'all know if I see anything. If y'all see anything, definitely email me and let me know. Because, I mean, we going to cover this trial on Monday, but I don't know about all these people that want to cut people up and stuff. I can't. It hit different with me. Like, all right. 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 All right. And we out of here.